This is the time and place for hearing to consider new waste discharge requirements for irrigated lands in the grasslands drainage area. Is there anyone present who is contesting the proposed action and wishes to present evidence or testimony on this matter? Since there is no one present to contest this matter, the board will proceed based on the agenda materials in the record. Are there any late revisions or staff comments?
Yes, Dr. Longley. There are late revisions. Oh, there are cards.
Does council have any legal issues to discuss at this time?
I do not.
Hearing's now closed. The chair will entertain a motion to adopt new waste discharge requirements.
I so move with the late revision.
Do I have a second?
Yes, I second.
Carmen moves. Denise seconds. Call the roll, please.
Mr. Schneider, Ms. Ramirez, Mr. Costantino, Ms. Kadara,
Yes.
Dr. Longley,
Yes?
motion carries.
Very good, thank you. As I announced earlier, agenda item 19 is off the agenda. We'll then move to agenda item number 21. 20, excuse me, I'm sorry. This is the time and place for a public hearing to consider an administrative civil liability order for Brightburn Operating Limited Partnership. The designated parties for this proceedings are as follows: the board's prosecution team and Brightburn Operating Limited Partnership. All other parties are considered interested persons. The prosecution team has a combined total of 30 minutes for direct testimony, cross-examination, and a closing statement. Brightburn Operating Limited Partnership has a combined total of 30 minutes for the same. Interested persons shall limit their comments to 3 minutes, and a timer will be used. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear that testimony you're about to give is the truth? If so, answer, I do. I do. Thank you very much. At this time, evidence should be introduced on the following issues: whether the board should issue, reject, or modify the proposed administrative civil liability order. The order of this testimony is as follows: testimony by the Brightburn prosecution team, testimony by the prosecution team. Secondly, testimony by Brightburn. Third, cross-examination of the prosecution team. Fourth, cross-examination of Brightburn's. Fifth, comments by interested parties. And finally, closing statement by Brightburn, followed by a closing statement from the prosecution team. Please state your name, address, affiliation, whether you've taken the oath before testifying. If you have not submitted a speaker card yet, now is the time to submit one to Ms. Lanfranchi Rosardi, sitting over here at the staff table to my right. Does Regional Board Advisory Team Council have any legal issues to discuss at this time?
Not at this time.
Thank you. Are there any procedural issues that the designated parties would like to raise? Hearing none, we'll proceed with prosecution testimony.
Chairman Longley, members of the board, good afternoon.
Thank you.
My name is Ron Holcomb. I'm a senior engineering geologist in your Fresno office, and I've taken the oath. Before you is a proposed administrative civil liability order for Brightburn Operating Limited Partnership's Dow Chancellor lease in the South Belridge oil field in Kern County. The prosecution team is proposing adoption of an administrative civil liability order for $67,700 for discharges of 5,040 gallons of well treatment fluids to land. During my presentation, I will show you where the facility is located, provide some background information, including information about well treatment fluids, describe how the prosecution team arrived at the amount in the ACLO, and I will address comments made by Brightburn in its legal brief. The Dow Chancellor lease is located in the western portion of the San Joaquin Valley in Kern County, about 43 miles west-northwest of Bakersfield and about 8 miles southwest of Lost Hills. The area immediately around the lease is used for oil production and open rangeland. Tree crops are grown about a half-mile northeast of the lease. In November 2013, excuse me, the Central Valley Water Board issued orders pursuant to California Water Code Section 13267 to multiple owners and operators of oil and gas operations in the Central Valley region, including Brightburn. The 13267 orders sought information regarding discharges of drilling fluids, well completion fluids, and/or well treatment fluids to land at any discharge or well during the reporting period from January 1st, 2012 to the date the orders were issued, which in this case was November 15, 2013. In February 2014, Brightburn responded to the 13267 order by reporting that excess well treatment fluids from 24 wells had been discharged to 24 unlined drilling fluid sumps. In May 2014, a notice of violation with a second Section 13267 order was issued to Brightburn seeking more information about the fluids reportedly discharged. In 2013, when the discharges took place, submission of a report of waste discharge for the discharge of drilling fluids to land during the drilling phase of well construction was conditionally waived by Resolution R5-2008-0182. The waiver did not include the discharge of well completion fluids or well treatment fluids. I've mentioned different kinds of fluids that are involved with oil well drilling and production. At this time, I would like to briefly refresh your memories about what these fluids are and how they are used. Drilling fluids are used during the drilling process to carry cuttings to the surface and cool the drill bit. Drilling fluids include a mixture of fresh and/or saline water, fluids from the geologic formation, added minerals and solids, and smaller volumes of chemical additives to improve the performance of the drilling fluid. Added minerals typically include bentonite clay to increase the viscosity and stabilize the borehole, and barite to help control the flow of pressurized formation fluids into the borehole. Added solids are typically inert materials to control and seal zones of lost circulation. Completion fluids are used during the well completion process after the drilling phase is finished. Completion is the process of preparing the well for production. Completion fluids include saline water, typically potassium chloride water, residual drilling fluid, formation fluids, and treatment fluids in wells that have undergone stimulation treatment. Stimulation or treatment fluids include acid stimulation treatment fluid and hydraulic fracturing treatment fluid. For the purposes of this presentation, I will focus on hydraulic fracturing treatment fluid, commonly referred to as fracking fluids. Hydraulic fracturing treatment, or fracking, takes place after the well has been drilled and the well casing has been set. Fracking fluids are injected through the well casing at pressures designed to fracture the target oil-bearing formation, thereby increasing flow of petroleum from the formation to the well. Once the formation has been fractured, sand or other suitable materials pushed into the fractures to hold them open. After the hydraulic fracturing process has been completed, residual pressure may remain in the well. Positive pressure at the wellhead will result in the discharge of excess fracking fluids. When this occurs, these fluids are also referred to as flowback fluids. In July 2014, in response to the second 13267 order, Brightburn submitted a report with additional information about the discharges. The report stated that the previously submitted information was incorrect and that only 6 of the 24 wells had positive pressure at the surface after hydraulic fracture treatment. This caused 10 to 20 barrels, which is equal to 420 to 840 gallons, of fracking fluid to discharge to each of 6 unlined sumps. The report also stated that the other 18 wells initially reported as having fracking fluid discharges did not have positive pressure at the surface after hydraulic fracturing treatment, and that all fracking fluids remained in those wells. After evaluation of the 2014 report and review of additional information submitted by Brightburn to the California Division of Oil, Gas, and Geothermal Resources, the Central Valley Water Board prosecution team confirmed that fracking fluids had been discharged into the 6 unlined sumps at the 6 wells identified in the report. The discharge had taken place over a combined total of 17 days. These discharges violated Section 13350A3 of the California Water Code, which authorizes the assessment of administrative civil liability for the deposit of oil or a residuary product of petroleum. Once it was confirmed that a violation had occurred, the prosecution team began the process to determine a possible penalty. Section 13327 of the California Water Code requires the regional board to consider several factors when determining the amount of a civil liability. In addition to the requirements of the Water Code, the prosecution team must follow the State Water Resources Control Board's water quality enforcement policy. The maximum civil liability set forth in the Water Code is either $5,000 per day the violation occurs, or $10 per gallon of waste discharged. In this case, the maximum liability based on the number of days the violation occurred is $85,000. The maximum liability based on the number of gallons discharged is $50,400. The minimum civil liability, which is established by the enforcement policy, is equal to the economic benefit derived from the violation plus 10%. In this case, discharging the well treatment fluid to the sumps saved Brightburn the cost of renting tanks to contain the waste and the cost of waste disposal. These costs plus 10% are about $1,650. The prosecution team negotiated a settlement with Brightburn for $67,700. Brightburn signed the settlement agreement and stipulated order on February 18, 2015. On March 4, 2015, the Central Valley Water Board's advisory team rejected the settlement agreement and stipulated order, stating that the Central Valley Water Board should be given the opportunity to deliberate on an appropriate liability assessment for these alleged violations at a future board meeting. The advisory team went on to say that, in its judgment, the current controversies involving the regulatory oversight of energy development activities merit consideration by the full board. The advisory team instructed the prosecution team to prepare an administrative civil liability order for your consideration. In response to the prosecution team's proposed administrative civil liability order, Brightburn's attorney submitted a legal brief dated April 20, 2015, contending that there is no direct evidence of an inappropriate discharge, and that Brightburn could not have discharged more than 40 barrels of fluids to earthen sumps at 2 of its wells. Brightburn also contends that the fluid discharged was produced water and fresh water, not fracking fluid. Furthermore, it contends that when it said it discharged to a pit, Brightburn meant that it was discharging to a steel tank, not to unlined sumps. Brightburn's original responses to the second 13267 order were based on field evidence and were submitted under penalty of perjury. The new contentions that a lower volume of fluid was discharged to 2 impoundments instead of 6, and that the fluids were produced water and fresh water instead of fracking fluids, conflicts with the reporting required by the 13267 order. In addition, before today, Brightburn has not identified which 2 of the 6 wells discharged fluid. It should have at least provided well numbers after conducting its investigation to prepare the brief. Because of this lack of specificity and the submissions made under penalty of perjury in response to the 2 13267 orders, the prosecution team finds the new arguments unlikely. Also, Brightburn uses the terms sump and pit interchangeably throughout its submittals, which undermines the new argument that it really meant steel tanks. Brightburn contends that a penalty using the per-day calculation should not be used because it has been determined that there is an absence of protected water in the area of the Dow Chancellor lease. Both the per-day and the per-volume calculation methods were available to the prosecution team for determining the ACLO penalty. The penalty was agreed to by both the prosecution team and Brightburn as a fair amount while considering the requirements of the California Water Code and the enforcement policy. The groundwater quality was taken into account when the proposed penalty was reduced from the maximum amount by considering the harm that the discharge would pose to existing beneficial uses. In addition, the water quality control plan for the Tulare Lake Basin states that all groundwater in the basin has a designated beneficial use of municipal supply unless specifically exempted by the Regional Water Board. The groundwater in the vicinity of the Dow Chancellor lease has not been exempted from its designated beneficial uses. In summary, Brightburn discharged waste in violation of the Water Code. The maximum penalty was calculated to be $85,000. The prosecution team asserts that a penalty of $67,700 is appropriate. The amount recommended by the prosecution team represents 80% of the maximum penalty while taking into account the requirements of the California Water Code and the enforcement policy. The penalty provides a disincentive to Brightburn and sends a message to the industry that these kinds of discharges are inappropriate. The prosecution team recommends that the board adopt the ACLO for $67,700 as proposed. This concludes my presentation. I would like to submit this presentation, the agenda package, and the Central Valley Water Board files referenced in the agenda package into the record. I'm available to answer any questions.
Questions by members of the board? After you received this report, July 15, 2014, to what degree did you go out to attempt to validate the violations reported by this report?
That was after we received information about the 6 wells that had discharged, Dr. Longley?
That's correct.
Yeah, this is Clay Rogers, Assistant Executive Officer for the Central Valley Water Board, and I'll answer that. I mean, basically what we had done, and the reason we had sent the second 13267 order after we sent the first one, was because we had some questions about the initial responses to the 13267 order, and we needed clarifying information. So when we got the second one, what it had said was that there was positive pressure after they had completed their well stimulation activities, which meant that, you know, after they had applied all of the pressure to frack the subsurface environment, you know, and basically sealed the well off and pumped in their proppant or the sand, the well is still full of all these well stimulation fluids and other fluids that are potentially mixed with it. And then when they release the pressure, typically what we see is you get that flow back because the well's full of fluid, because if the fluid levels dropped, you wouldn't have any pressure. And what happens then is that that flows back into the piping, and in our experience, what we'd seen at a couple other places is that ends up in the sumps and basically, or the former drilling mud pits which are left on site. And so what we asked for when they originally said the 24 was we didn't know, and we got the information back after the second 13267 order that said there was the positive pressure at the 6, where we looked at the specific records that had been prepared while they were doing the fracking, their daily drilling reports, and that type of information that specifically talked about what they had. And so it was based upon that that we felt that it was 6 wells that discharged instead of 24. Now, after they said it was really 6 instead of 24 and presented to us a logical argument, now they've come back and said that it's 2 really instead
Well,
of 6.
All kinds of alarm bells go off in my head with this report.
Yeah, I mean, we
And-
were confident, Dr. Longley, based upon the pressure data that we had seen, that it was actually 6 instead of 24 that had the flow back. I mean, the problem is we were collecting information a year and a half, 2 years after it was done. You know, so it was a situation where we were dependent upon the information that was provided to us. We tried to look at it in an unbiased and fair manner to see what had actually occurred. And we felt that we could support that there was discharge at 6 and that it was reasonable at the other 18 based on the lack of pressure that there probably wasn't any flowback fluid. But, you know, to be honest with you, we don't know for sure one way or the other.
Yes, I mean, this document signed by somebody fairly high up in the organization, and I'm very concerned about the validity of the information that we received. Any further comments or questions?
I have one.
Sure.
Can you reiterate the reason that the settlement was rejected?
Sure. Okay.
I think the reason that the settlement was rejected is really a question for the advisory.
It is,
That's
and if you,
Oh, but that's fine, but it was in the presentation once
But-
already.
yes, but John, they're not the ones that rejected it.
They quoted the letter that
That's
the
fine.
advisory
Okay.
team wrote. And essentially, upon, the process goes forward such that the prosecution team issues their complaint. Oftentimes, that results in a settlement, and then the settlement comes to a neutral delegee of the board, in this case, it was Pamela and myself, to take a look at that settlement and see if it falls within the scope of settlements that the board would be comfortable having Pamela sign using the board's delegated authority. In this case, due to the fact that this was one of the first fracking fluid discharge cases, it really, and due to the fact that the settlement was fairly scant on the details that led up to the settlement, we reasoned that this would be a matter that, for policy reasons, the board should consider as a whole. So it was left up to the prosecution team and the discharger to see how they would proceed. The avenue could be, collegial, it could be adversarial, and how this was brought to the board. But it's certain we wanted the board to retain full discretion to go higher or lower as per the requirements of the water code and the enforcement policy after deliberating on what occurred out here.
Any further questions, John? Any other questions or comments by members of the board? Thank you. We'll take testimony now by Brightburn.
We have some connection issues, and it'll take just a minute to reconnect for the public watching the.
I've been told I have that effect on cameras.
So we'll take a short recess.
we're back. We're back on.
Are we back on? Because I was going to ask you questions about the camera. I'll do it later. About the system that we have, which I have great concern over.
Good afternoon, Doctor.
And it's not you in the camera.
Well, it depends who's levying the accusation.
That's right.
First of all, thank you very much for
You'll need to
letting
get
us-
closer to the mic, though. Sorry. You have to be a rock star.
I can do that. That comes naturally. My name is Daniel Clifford. I'm with the law firm of Clifford and Brown located in Bakersfield, California. I am here today on behalf of my client, Brightburn Operating. I would like to thank you for giving us the opportunity to present evidence before this hearing. I think that you will find that upon the completion of our presentation that you will see that the representations made in the filings presented to the prosecution team were done in good faith, and they were done based upon information that was available at the time. With me today and who will be testifying will be Martha Brock at Brightburn Brightburn Operating. She is the regional EHS manager at this time. She was responsible for performing the oversight of the investigation. I also have with me, to my immediate left, Dennis Weiss. Dennis is employed by Brightburn Operating. He is their drilling foreman, production foreman. And lastly, I have Brad Pierce. Pierce is formerly employed by Brightburn. He was their engineering and drilling engineer. Mr. Weiss and Mr. Pierce have 60 years plus of combined experience working in the oil fields. Mr. Weiss has approximately 30 years working in the Bell Ridge oil field. He is extremely familiar with that formation and what it is capable of doing with respect to pressures. I would like to just give you a very brief outline of the testimony that we will be presenting today, so it's not something that you are hearing in the context of a vacuum. First of all, Brightburn took responding to the request for information incredibly seriously. Ms. Brock will echo that. When Brightburn got the request, it did everything it could possibly do to garner the information that the prosecution team was looking for in order to allow it to arrive at its own conclusions with respect to whether or not there had been a discharge. The initial conclusion was that there may have been discharges at 24 wells. Understanding that Brightburn has an obligation to make sure it fully complies, it elected to over-report because it's much better to give more information than not enough. And that was the assumption that was made when responding to the request. The advisory team sought additional information following its receipt of Brightburn's initial submission, and it was based upon the review of that information that it was determined that discharges may have occurred at 6 wells.
To clarify, that was the prosecution team.
Correct. I misspoke. It probably won't be the last time either. I apologize. When Brightburn got together with the board and with the prosecution team and entered into the stipulation for the penalty of $67,000 and change, it was done so knowing that it had information in its possession at that time that if there were discharges, it was possible that they were at 2 wells. In an effort to streamline the process and go ahead and stop the investigation associated with looking into the potential discharges, Brightburn agreed to enter into the stipulation. And that was the driving factor that eventually led to the agreement. Once it was determined that the stipulation had been rejected, Brightburn elected to defend itself, which it is entitled to do. And it was upon that determination that Brightburn has developed this defense, which is based entirely upon fact. And Mr. Pierce and Mr. Weiss will be able to explain the wells by location and by name, and we'll be able to explain why we believe that there is absolutely no evidence of a discharge. So with that, I'm going to go ahead and start to elicit testimony initially from Ms. Brock. First of all, Ms. Brock, just from a background standpoint, your employer is Brightburn, true? And your current title is EHS Director? I just gave you a raise.
Oh, I'm sorry.
Can you briefly outline your job duties for the board?
Yes, as the H&S Regional Manager, I'm tasked with developing and overseeing compliance and other matters relating to environmental, health, and safety of our facilities and our workers. including permitting, compliance programs, implementation of compliance, training, plan preparation, and reporting.
In that position, you were tasked with oversight of Brightburn's response to the request that came out in November of 2013.
Yes.
Can you just briefly describe what it was that you did in order to gather that information?
I assigned the overall implementation duties to one of my senior task members. And then from that, we gathered with some of our production engineering people who had experience in the field and in these operations to elicit their assistance in getting the spreadsheets filled out, which were the initial submittal requirements. And that's basically what we did.
All right, and did Brightburn take its receipt of the request for information seriously?
Oh, very.
What was your role with respect to responding to the request for information after you were provided with the documents that you directed your staff to gather?
We reviewed the documentation. We interviewed the staff, including the operations engineers that had put the information together to make sure that we were satisfied that it was accurate. And then we were responsible ultimately for putting it into the format that we were given for the report. I will also add that during the January 1, 2012 to this 2013 period, Brightburn had not owned the property until December of 2012. So part of that time was spent in trying to pull the records of the previous operator, who was American Energy Operators, and pulling their records so that we can fill out the 2012 portion as well.
What did you do, if anything, upon your receipt of the request for further information from the prosecution team in the spring of 2014?
We reviewed the report that we had submitted, and because initially at the bottom of the report requirement it says that it has to be signed by either a civil engineer or professional hydrogeologist, we went ahead and I contracted out to our hydrogeology firm that is familiar with that, the geology and the hydrology of the area, and oil operations as well. And I asked her to go back and independently review all the data we had gathered. And upon her investigation of all of the records and so forth, she was the one that came and brought to our attention that your records do not show discharge to 24 sites, but instead it was only to 6 because of the pressure.
And again, it was, at that point in time, had there been a confirmation of an actual discharge versus a potential discharge?
No. Again, this is all information from after the fact, so we're trying to reconstruct things that happened a year and a half, 2 years later.
Eventually, Brightburn agreed to meet with the prosecution team, and there was the stipulation for imposition of civil penalties.
Yes.
And Brightburn agreed to enter into that,
Yes.
correct? At the time Brightburn agreed to enter into that settlement, were you aware of the issue concerning only 2 wells actually being potential sources for discharge?
Yes, we were.
And even so, you elected to enter into the settlement agreement?
That's correct.
Or at least Brightburn did?
Yes.
Two of the individuals that you sought assistance from in terms of performing an analysis of the well data are Mr. Weiss and Mr. Pierce. True?
True.
Okay. I would now like to go ahead and move to Mr. Pierce, and he will be able to provide you with the basis for why we have concluded that there are only 2 potential sources of discharge versus 6. And I reiterate that it's a potential source. There is no credible evidence of an actual discharge. And Mr. Pierce is going to explain to you how we got to that conclusion.
Counsel, will you ask your witness to provide us with the name of the initial engineer hydrogeologist that gave you the initial information about the 6 wells? You said that she...
The second report?
Yeah.
It was Waterstone Environmental, and the work was overseen, well, mostly conducted by Nancy Boreski, who is a hydrogeologist, and also in concert with Jeff Dagagian, who is a principal there as well.
Thank you.
Just from a background standpoint, Mr. Pierce, I think it would be helpful if you can, in 30 seconds or less, provide the board with a background concerning your experience in the oil and gas industry as well as your education.
Can you hear me? I got to turn on. I'm sorry. Thank you. I'm on now. Well, again, my name is Brad Pierce. Thank you very much for allowing me to be here today. I graduated from California State University at Long Beach in 1980 with a degree in chemical engineering. I proceeded then to enter the oil and gas industry. I left California, moved back to Texas, spent the next 20 years in Texas being a production engineer and operations engineer, drilling engineer. I was involved in environmental health and safety also during that time frame. In 2000, I moved back to California and came back to work and became an engineer for a company in Long Beach, and then another one in LA, and then eventually landed or came to work for Brightburn in 2005. I then went back to school and graduated from the University of Southern California with a master's degree in petroleum engineering. And after my graduation, I was asked to be an adjunct professor in drilling operations and for a drilling class. Since then, I've left Brightburn and became my own engineering consultant, consulting to other oil and gas companies in the LA Basin, at this time. I'm sorry, what was the rest of the question?
Well, I can see that with your degree from USC, you didn't learn how to keep track of time.
That's on purpose.
All right, Mr. Pierce, you are involved in some of the analysis associated with Brightburn ultimately concluding that if there were discharges, they may have been at the two wells that we are going to identify in a second. True?
That is correct.
And for purposes of performing that analysis, what documents did you review?
I reviewed our individual well report sheets. I reviewed the histories that have been submitted to the DOG, and then some additional well report sheets that we had available. And in two of those wells, the Triple J5 and the L-12, those two wells specifically identified that there had been flow to the sump. And so that, in that essence, I took that to mean that it was to the earthen sump. There were also references that the wells, at certain points in time of the day, they had blown the wells down, or that they had hooked those wells up to a flow line and flowed the wells back to our production area or to a pit. In my understanding, that the pit referred was a reference to the steel pits that we had available on location.
What is a steel pit? Just describe that, because it's referenced in the documents you reviewed.
The steel pit then becomes a container of some size, could be 6 by 10, could be 8 by 12, constructed out of steel that we are able to pull fluids from and deliver them to a certain location, or just leave them in that pit.
In your experience of many years in the oil and gas industry, is there a distinction between the words pit versus sump that you are familiar with?
That's always been my understanding and the way I've approached it, that a pit referred to the steel pit and the sump was the earthen containment.
We managed to narrow down the list of potential wells where possible flow occurred to the earth. Those wells and the documents you reviewed were attached to the submission to the board. True?
Yes, sir, I believe that is correct.
All right, and those are identified as exhibits 1 through 6 to Brightburn's submission. For purposes of this question, you ultimately concluded that there may have been flow at which wells?
The Triple J5, JJ5, JJJ5, and the L-12.
And that was based upon what information in the well records?
They specifically said they had flow to the sump.
Did the other 4 wells have any reference in the documentation that you reviewed to discharges to a sump?
No, no, sir. I don't recall any, but no, sir.
Now, you were present on June 6, 2013, which was the date that the well records you reviewed referred to a blowdown to sump. True?
That is correct.
All right, and you were there when that action was occurring, true?
When the action was occurring, that is true, yes.
At least for some portion of it.
That is correct, sir.
When that event was occurring, did you see flow of fluids going into the earthen sump?
I did not.
What did you see?
What I observed at the time was a blow of gas with liquid droplets entrained in the gas.
As you sit here right now, are you capable of providing the board with any estimate as to the quantity or quality of the flow that you saw emanating from the well into the sump?
No, sir, since it was just droplets, I am not able to quantify a volume.
I want you to assume for a moment that there was a flow from the well. From what you were able to see, can you quantify or tell the board whether or not it was 1 barrel versus 5 barrels versus 10?
I don't believe I could do that, no, sir.
Would you be speculating?
It would be complete speculation, yes, sir.
Mr. Weiss, you're up. First of all, Mr. Weiss, can you please tell the board where you are currently employed?
Yeah, my name is Dennis Weiss, and I'm the production foreman for the Bell Ridge field. I worked for Brightburn for approximately 2.5 years, and prior to working for Brightburn, I worked on the same property since 1986. I've been in a production foreman capacity since about 1992.
You have had an opportunity to review the well reports and daily rig reports for the 6 wells where it was thought that there may have been a discharge, correct?
Yes.
All right, and you have now heard Mr. Pierce testify concerning the 2 wells where there may have been a discharge. And he's indicated that it was at J5 and L12. Did you hear that?
I did.
Do you agree with that conclusion?
I do agree with that.
And you've also heard him discussing the distinction between a reference in a daily rig report and a well report relating to sump versus pit.
Yes.
All right, and do you agree with that?
Yes.
Is that the standard vernacular used in the industry?
Yes.
You were present at the same time Mr. Pierce was present on June 2nd, 2013, when the well J3 was, J5 was shown that it had flown to the pit, true?
I was. Yes.
Okay, and are you able to describe what you were able to observe when that was occurring? In other words, can you describe the quantity or quality of the discharge, if one even existed?
The volume that was discharged to a pump to the sump was primarily gas with small entrained fluid droplets. I don't know if you want me to elaborate on the pressure situation.
Absolutely.
Okay, what had happened on J5 was we were in the process of completing the well, going in, retrieving bridge plugs and cleaning it out. The well had begun to flow, so we connected a flow line to let the well flow into the system until the pressure dissipated where we could safely go back to work on
Let
it.
me stop you there. You've said flow into the system. Please explain that.
Well, you know, usually what we want to do first and foremost is to keep the red contractor safe and the crew that's working on the well. So if we see any flow at all, we'll suspend the operation, and we can either do that by completely shutting the well in or tying it to a flow line that lets it flow into the system where the water and the oil are processed. The oil is processed for sale, the water is processed for reinjection into our water flood. So that was done on Triple J5. We came back the following morning, and the well had only system pressure on it, which was 40 psi. That's what we maintained on our gathering system for the system. So when they arrived there and they saw the 40 pounds, they closed the valve, knocked the hose loose, and then just inadvertently opened it up. And when they did, it blew out a little bit of gas with some liquid droplets in it. That's the extent of the flow that went to the sump on Triple J5.
Have you explained the issue with respect to the pressure? I knocked you off of your train of thought. I wanted to make sure that you were done.
Right, I'm done.
Perfect. You were also present at the time that it is alleged that there was some sort of discharge at well L12, true?
That's true.
Can you please explain for the board's benefit what occurred with respect to that incident?
A very similar situation happened at L12 and Triple J5. However, on well L12, all of the subsurface work had been completed. The rods and the pump had been run in the hole, but we did not have a pumping unit on location yet. So the well sat idle for 6 days with the flow line open to the system. And then when the pumping unit arrived, we went back on the well to install the well on the pumping unit. After an effort was made to try to get the well to pump up, it wouldn't pump, so we recognized a mechanical problem. And when we went back to fix that, the line again was disconnected and the well was allowed to flow to the sump for maybe 3 minutes, which again was just gas. In all oil wells, whenever you leave them shut in for a little while, the pressure column in the well is fluid at the bottom and a gas pad at the surface. So whenever you open it up to bleed that 40 pounds off of it, it's gas. I've never seen any liquid surface.
In the case of well L12, did you see any fluid bleed to the sump?
No.
Was it like you've previously described, gas vapor?
Yes.
Mr. Pierce,
Yes, sir.
I've placed before you a copy of part of what we submitted with our brief, which was Exhibit 4. And what I've given you, or at least what's before you right now, is the second page from the history of oil or gas well. In arriving at your conclusions that well Triple J5 was one of the wells where there was possible flow, did you rely on the language that's identified there with the date next to it of June 2, 2013?
Yes, sir. Where it says well flow, allowed well to flow into sump.
Yes, sir.
Yes.
Was that the only reference that you were able to find in the documents that you reviewed that related to the term sump or flowing to sump?
For this particular well, yes.
Does Brightburn rely on the accuracy of these documents for purposes of conducting its business?
They do, yes, sir.
And this was submitted to the Dogger, true?
This is submitted to, yes, that is correct.
Mr. Weiss, one of the documents that you reviewed for purposes of performing your analysis would be the well crew reports, true?
That's true.
What are the well crew reports for?
Basically, the well crew reports are reports that are filled out by either the workover rig pusher, or they're filled out by a consultant who basically helps supervise the workover jobs. Then those documents are used to go in our well files and well records for future reference for upcoming work. And secondly, those same documents are used to provide the well histories to the Division of Oil and Gas.
I'm drawing to your attention the very last entry, which is the last page of Exhibit 6, just to direct the board to where I'm referencing him. It includes some language down at the very bottom. It says summary, and then it includes some initial language, and then there's a sentence in there that says pump bled well to sump. Do you see that?
I do see that.
Is that the only reference in all of the documents that you were able to receive, or pardon me, review, that indicated that there had been any potential discharge to a sump?
Yes.
With respect to well L12, are you able to provide the board with any kind of estimate as to the amount of fluid, if any, that was bled into the earthen sump?
No.
You'd be guessing?
Yeah.
Make sure you keep it.
I would be guessing. Sorry.
Yeah, in closing, Brightburn has taken this matter seriously. Brightburn wants to be a responsible corporate citizen. Because Brightburn has had the opportunity to analyze this information and review it, I can tell you that there was absolutely no malintent for purposes of trying to ascertain whether or not there was a flow. Brightburn takes the orders and the laws of the state of California very seriously, and would not intentionally place flow in the system, or pardon me, in the sump that would cause a violation. So I would ask that the board, when issuing a penalty, even if it's going to go that route, elect to not issue a penalty. There simply is no credible evidence to indicate that there was a discharge to a sump. Any penalty issued by the board would be based upon rank speculation. Now, in the event that that's where the board is going to go, we have suggested a number in our brief at 18,000 and change. I would obviously ask that the board consider the lower amount because of lack of evidence. With that, we'll take questions.
Any questions? Thank you. This time, I call for cross-examination of the prosecution team.
I think I can use my 51 seconds effectively. I'm just like Mr. Walker.
No, we're going to do cross-exam of the prosecution team at this point in time?
That's what he's suggesting.
Yes.
Prosecution up or prosecution by?
Prosecution, cross-examination of.
Of the prosecution team.
Just sit right there. Thank you. You're welcome.
Kind of moved in.
That's fine.
Good afternoon, Mr. Wachtel. How are you?
Very good.
Good. Quick question. What documents did you review when assisting in arriving at conclusions that there had been a violation?
I reviewed the initial spreadsheet in response to the first Section 13267 order. I reviewed the July 2014 technical report prepared by their consultant. And I reviewed publicly available information on the Division of Oil and Gas's Well Finder website.
which included the information reported to the Dogger by Brightburn?
Yes, I did. I specifically reviewed the 24 history of oil or gas wells reports submitted for all 24 of those initial wells on the initial spreadsheet.
Very good. In your review, did you locate any documents that confirmed for you that there had been a flow of any quantity into an earthen sump?
Flow, yes. Volume or quantity, no.
So as you sit here today, you are not able to say one way or the other if it was a gallon versus 10 barrels versus 20 barrels. True?
Correct, true.
Thank you, Board. That's all I needed.
At this point in time, I call for cross-examination of Brightburn.
The more the merrier.
Yeah. Just in case. They can just all sit there. Oh, okay. Then Mr.
Where's the chair?
Good afternoon, Mr. Weiss. My name is Julie Macedo. I'm Senior Staff Counsel for the prosecution team in this matter. Does Brightburn have a standard operating procedure for having pits on the site?
I can't hear you. You need to turn the mic on or get closer to it.
Yeah, Brightburn's current policy is that whenever we have to circulate a well or we have to move a pump on a well for circulation purposes or workovers, that we have a pit associated with that well and no earthen sumps for anything except the drilling process.
When are they placed at the site?
And Julie, can you hold that question?
Sure.
Let me ask, because I would like to know, you said, sir, you said that is the current policy. Is that also the policy at the time of the alleged discharge?
Yes.
Okay, you're welcome. When are they placed at the site?
Okay, after the fracturing process is complete and the wells that we complete on the Bell Ridge Field for Brightburn, there are multiple stages that are fracked. Once the well has been fracked and it secures, we move in the workover rig, we move in a circulating pump that also has a tank on it, and then we move in the pit before the work starts.
Are pits used for every well drilled?
Sir, I appreciate it very much. You're going to have to, as was previously stated, you're going to have to act like a rock star. Get close to that mic and speak into it, please.
Okay, I will, sorry.
We're having a hard time hearing you.
All right, sorry.
Are pits used for every well drilled?
Yes.
Okay. You testified earlier that the drip line was placed back into the system. Where did the drip line terminate?
The drip line?
Yeah, for well JJJ5.
I'm not sure what a drip line is. I'm sorry.
At the flow line?
The flow line. Okay, I'm with you. When was it installed?
No, where did it terminate? You said it was placed back into the
Okay.
system.
Okay, basically what happens when we are in the process of completing new wells at Bell Ridge, there's a metal flow line that runs up to the edge of the location prior to the drilling rig moving in most of the time. Then when the workover rig moves in to complete the well, there's a poly line that's installed from the wellhead to the flow line. Oftentimes those aren't connected until we need it, but it's there and ready to use.
Okay. Can you look at Exhibit 4 that's on everyone's screen? I have a copy for you if you'd like it. On June 2nd, 2013, it states that Brightburn allowed well to flow to sump. And on June 6, 2013, well had oil flowing, hooked up poor boy and bled down well to pit. Why was the word sump used on one day and then a pit would be used a few days later?
You know, I can't answer to that other than the rig crew just disconnected the line, threw it over by the sump, and opened the valve. They typically don't flow it any place if there's not enough pressure to flow liquids out of.
Okay, I don't have any more questions for you. Thank you. Mr. Pierce,
Yes, ma'am.
did you interview the people who prepared the daily reports?
No, ma'am.
Okay. I do have one question for, an additional question for you. You testified that for the first time today, you identified for the prosecution team that the two wells that allegedly discharged two sumps were Triple J5 and L12. Is that correct?
Yes, ma'am, that is correct.
Okay. Well API number 03050420. I believe that's well I4. Is that correct?
I have no idea.
Okay, well, your Exhibit 2, Brightburn's Exhibit 2, I believe you reviewed all the material you submitted in support of this hearing, states on June 13, 2013, Day 6, arrived at location and held safety meeting. Oh, excuse me, July 12th, 2013. Day 5, arrived at location and held safety.
July or June?
Sir, excuse me, June 12th, 2013. Day 5, arrived at location and held safety meeting. Service rig, bleed well, had to PSI ? To kill well. Oil coming from tubing and backside.
Okay, well, I apologize. I don't know that I'm looking at the same page you are.
You're not looking, that's not the document. It's Exhibit 2, that's Exhibit 4. Can you get the material from your counsel, please?
No, this is Exhibit 2. You're referring to well I4.
I am looking at Exhibit, yep, I4.
Okay, so you're looking at the history, at the DOG history.
Right,
Okay, thank you, I'm sorry.
that's fine. June 12th, 2013, oil coming from tubing and backside. That is a third well indicating a discharge.
Yes, ma'am.
Nothing further. Question for Ms. Brock. Do you want to move? Mr. Clifford?
Sure, I'll
You know, I'd like to have him elaborate on that response, please.
Yes, ma'am.
Well, if you could just elaborate, because I believe your testimony a few minutes ago was that you were certain, or fairly certain, I thought, that there was just two wells, and right now, I think your testimony just said that there's evidence of a third well.
All it says is the oil was coming from the tubing to the backside. Doesn't say where it was going, doesn't say if it was going to the pit, it doesn't say if it was going to the earthen sump. So all it says is that there was tubing, that there was oil coming from the tubing to the backside.
Okay.
And so I can't make a, go ahead, I'm sorry.
No, you're going exactly where I wanted you to go. So on the other two, you testified because you're certain where the end point was going to. Here, it just says that there's something coming out the backside, but you don't know where that's going.
That is correct.
Okay.
That is correct, yes, ma'am.
Thank you.
Ms. Brock, I believe you testified today that you took the response to the second 13267 very seriously, correct?
The first one and the second one.
Thank you. It sounds like you interviewed the staff. Did you interview Mr. Weiss before submitting it?
The second or the first?
Either.
The second one, I believe Nancy Boreski at Waterstone took the lead on the investigation.
Did you interview the people who prepared the daily reports?
No.
Okay. Did you know that the 13267 reports are punishable by 13268 penalties for failing to provide proper information?
Maybe not those exact sections, but yes, I realized.
And Brightburn provided volumetric information in both gallons that it discharged, correct?
In the spreadsheet, yes, the first spreadsheet.
Okay. And in the days that it fracked material to the sumps, yes?
Sort of, yes.
Okay. And so you also testified that at the settlement meeting with the regional board,
Counsel, that wasn't testimony. Oh, I'm sorry. I thought you were talking about at the meeting.
Sorry, today you testified that when you had met with the regional board earlier this year, I believe, that you or Brightburn was aware that, or you held the position that only 2 wells may have discharged rather than the 6 that the second 13267 order had described. Is that correct?
That's correct.
Yet you never identified those wells to the regional board prior to today. Is that correct?
I know I had a discussion at the settlement with somebody at the regional board. We just sort of chatted that we thought there was really only 2, but we didn't go into any detail because we were willing to accept the settlement at the time.
Do you know who that person was?
You know, I don't recall. There were quite a number of people at the thing.
Do you see that person here today?
I don't think it was Doug. It
Okay.
might have been Dane.
Okay.
Or the guy that was sitting next to him, but it was just a very informal reference to it, but we didn't make a big deal out of it, no.
Okay. Thank you. I don't have anything further.
I have one. Dr. Longley, this is Clay Rogers, Assistant Executive Officer. I have one clarifying question for Mr. Pierce, I believe. And that question is since you did not interview the person who prepared these documents that appeared to us to interchangeably use the words sump and pit, you do not know what that person intended when they wrote those when they used those different terms.
I do not know what that individual intended, no.
Thank you. No further questions.
Thank you very much. At this point, I call for a closing statement by Brightburn.
Just to double check, we don't have any interested parties.
I don't believe so, and I should ask. I don't have any cards for interested parties. Is there an interested party in the audience that wishes to testify? Seeing none, we go to closing statements. You got 31 seconds. I'll give you a minute and a half. How's that?
Microphone.
I heard this board say earlier today, because I had about 4 hours to watch the goings-on of the board, and I commend you for the things that you're doing. One of the things I heard said was that the board needs to have competent data to reach a decision. In this case, there is no competent data to warrant the imposition of a civil penalty. There's guesswork, there's supposition, there's speculation. We can try to interpret these documents after the fact, and Mr. Weiss and Mr. Pierce have done their best to interpret what was going on out at those well sites over 2 years ago. Both of these gentlemen have an enormous amount of experience working in the oil and gas fields. And although they're not mind readers, I can tell you that this was not their first rodeo when it comes to reviewing well reports or submissions to the Dogger. Brightburn feels confident in the conclusions that the two of them have arrived at with respect to where these potential flows could have occurred. At the end of the day, there simply is no evidence to allow for the imposition of a penalty. Brightburn asks that the board consider its request that a penalty of $0 be entered. Alternatively, if the board feels that it is compelled to do so, we would ask that it do so for the lower amount set forth in our brief. I thank you for your time.
Thank you. You know, I'm certainly not against fracking if it's done in a manner that's protective of the environment, and the criteria for that's been spelled out. And so I see this certification statement here, and in no way does the testimony I've heard since then explain why this document was signed in the first place.
I will address your question this way. I believe that Ms. Brock indicated that when they executed the document, and I think that it is the certification, it was based upon the information that they had at the time, and it was done so in good faith. So there was absolutely no malintent. There was an intention to comply and comply fully with the request. So perhaps I can answer another question to try to build on that, but there simply was no intention to mislead anybody. The prosecution team, the board, it was after they had the opportunity to analyze the additional wells and then further drill down, and I believe that Ms. Brock even touched on it. The prosecution team was advised of Brightburn's understanding that if there were discharges, it was at 2 wells.
Yeah, I'm still left with 3 possibilities. One of those is intent to mislead. The second one is that there was some pretty damn sloppy work done. Well, I'll stick with 2.
And we can elaborate on those in deliberations.
We will, yes. So with that said, call for closing statement by the prosecution team. I'm done, sir.
Doctor, may I just address that last point, please, that you made?
Go ahead.
And I'll be brief. If there was an intent to mislead, there wouldn't have been a reference in the documents submitted to the Dogger, another governmental agency, that there had been a flow to the sump. So if there was an intent to mislead, those documents would be scrubbed to that.
You've heard my concerns. Thank you. Closing, please.
Good afternoon, Dr. Longley and Chairman and Chair of the Board and members. Again, Clay Rogers, Assistant Executive Officer. I guess with this one, you see kind of the situation that the prosecution team has been in with this. I mean, we got additional information in the beginning that said that there were 24 wells. It was really unclear to us what had been done, so we requested additional information through a second order to try and clarify that. Based upon that, we felt comfortable that the discharges had occurred at 6 wells, that there probably had been actual discharges because they had flown back pressure. When we looked at the documents, it appeared to us that sump was used occasionally, pit was used. Didn't make sense to us that if they had pits on site all the time, that they would discharge to a sump instead of the pit, or you know, if their just regular practice was to discharge to the sump, which we had seen at a couple other instances. You know, certainly when we looked at the potential settlement, we thought the $67,700 was an appropriate amount for a couple reasons. Those reasons were because there were uncertainties about what had been done. It was close to the statutory maximum, although not all the way at the statutory maximum. Our real intent here was to follow the enforcement policy and put a message out there as a deterrent, not only to Brightburn, but of the other companies that say, you need to make sure that this does not occur. This is not a proper practice, and it needs to be stopped. And we felt that a penalty of $67,700 would accomplish that and be able to settle it without having to come and have a hearing and take up the board's time because of all the work that we need to do. You know, that settlement was rejected, which certainly is the prosecution team. We understand why that was done. But we'll go on. You know, we thought their evidence that it only occurred in 2 wells, it isn't clear to us that it only occurred in 2 wells. You know, we are totally dependent upon the information provided by what Brightburn provides. I do think in the beginning that they may have over-reported, at least initially. You know, when they found out what the consequences of their reporting action was, I think they decided that they seriously needed to go back and take a look at it. As we looked at, the difference between 24 wells and 6 wells. There are actually records about what the pressures were when they bled the wells. And in 18 of the wells, it appeared to us that there was no pressure when they cut loose the lines, and therefore flowback would not have occurred. So that was how we came to the 6. I guess at the end of the day, we thought 67,700 was appropriate, but I don't really have a recommendation here to that. I mean, you've heard the evidence and the testimony, and I'll leave this matter to the discretion of the board members and the advisory team for what the proper penalty amount in this case is. Thank you very much.
I would ask one question. If you could elaborate on how you arrived at the 17 combined days a little more for the board.
The 17 combined days that we derived at were the days where we thought actual discharges had occurred into the sumps. On those wells where there had been fracking operations, there were multiple stages being done. So at each stage, they have to disconnect the lines, and where it looked like it had pressure and there was flow back. That's how we came to the 17, basically, different days that discharges had occurred.
Is that per well?
That's the sum of all the wells, the 6 wells.
Are we talking 17 days spread amongst 6 wells?
Yes.
Okay.
It's not 17 days per well.
Can I ask you further, Clay? Are those just for the days of discharge, or was it for the days between the time they discharged and the days they, according to the report submitted by Ms. Brock, the day that they actually removed the liquids from the sumps?
Those are the days of the actual discharge. You could look at the days that any of those fluids were present in the sump that potentially could have leaked out the bottom of the sump, and those days probably would be a larger number of days than the 17, although I can't tell you off the top of my head how many days that would total for the 6 wells. From the first time that we thought there could have been flow back until the day at which that had been removed. I believe that would be more than 17 days total.
I think it would be. Thank you.
Any questions? Board members? Thank you very much.
Thank you.
With that, I'm going to close the hearing and ask the advisory team for input.
If I could weigh in, during the course of this presentation, and certainly while we were reviewing the materials that were submitted by both the prosecution team and the discharger, it almost became apparent that this case is less about a small volume of fracking fluids discharged to a small number of sumps than it is a case about sloppy reports being turned in under penalty of perjury and very little effort taken to correct those misconceptions, those sloppy use of terms, and the inaccuracies in terms of what was discharged to what wells. When you're a prosecutor prosecuting a case and you have an affirmative duty to correct perjury, you don't have an affirmative duty necessarily to correct perjury if you're on the defense side in a criminal case. And I don't see that the board has any reason to believe that these reports were submitted maliciously, which certainly gets you off the hook from a criminal prosecution, which can take place in these contexts if those reports were submitted under penalty of perjury with intent, with knowledge that what happened was different. But that does not get you off the hook of potential liability under Water Code Section 13268 or 13268. 13268 has a maximum penalty of $1,000 per every day where you fail to turn in a complete technical report to the board. I would say that these material deficiencies in the reports that were submitted could potentially form the basis of a separate administrative civil liability action of up to $1,000 per day for each report that was materially deficient and was not corrected by the board, by the discharger. Knowing that there's a few reports out there, that amounts to a very, very significant amount of potential civil liability. Again, the way this particular case was charged, it was a charge of discharging to waters of the state, which is the discharge of fracking fluids to unlined sumps. This very easily could have been a case about sloppy reporting and failing to correct material deficiencies in reports submitted to the board. I don't think that we have a lot of evidence, very specific as to how many sumps were discharged to and the volumes that were discharged to. I think we have very solid evidence that there were at least 2, as many as 6, and that there was some volume of fracking fluids discharged to those wells. I do think that gives the board the discretion to issue the administrative civil liability order in front of it today. I do suggest that with respect to the defense's comment that we don't have enough evidence in front of us to issue any civil liability, that we actually do, and we have the evidence in front of us to issue a much, much larger civil liability, albeit not how it was charged today. It's within your discretion how you want to treat this matter. I think that that even if you run through the penalty calculation in the penalty methodology that's in the water code, or the water enforcement policy promulgated by the Office of Enforcement, if you run through that, you wind up with a number that's either $16,000 or $18,000, right in that ballpark. I think the failure to provide rectified reports when you have full knowledge that the reports that you submitted to the board were false or contained material deficiencies gives the board the discretion to elevate that discharge to at least the $67,000 that the prosecution team has proposed.
Let me ask this. Under 13268, are there any exceptions when somebody is relying on the representation of a professional? So in this case, Miss Brock was relying on the engineer who had prepared the report.
I think it lies largely within the discretion of this board. There aren't any precedential orders on the part of the state board that says what failing to provide a report to the board is in that context, in that particular context. So ordinarily, when you have something that falls within the enforcement discretion of the board, say you have a report that was submitted that has material deficiencies. Somebody comes back to the board and says, that report I submitted 6 months ago, we made some errors. We called sumps pits, or we called pits sumps, anything of that nature. We would much prefer that you not assess a civil liability for those 6 months in which you had a bad report in your hand and we knew about it. That is, and the board very rarely sees cases like that because that's not a realm in which we choose to exercise our discretion to prosecute those cases. We have bigger fish to fry, and when there's those type of mea culpas, we try and put those as a low priority for enforcement purposes. This might be a different case. It's up to you to whether that's appropriate, in which you'd instruct the prosecution team to see if they see fit, if they have enough to support the basis of a new administrative civil liability order that charges that. Or the other alternative is you go with the administrative civil liability order that's in front of you today and use the material deficiencies as justification for the upward departure from the penalty that the enforcement policy would ordinarily require that you assess.
Well, the reason this order came to the board was the fact that when you read the record, it was very unclear. And it is a fracking issue, which, as I stated previously, fracking is acceptable practice as long as it's done appropriately. But when the board receives bad reports, information that it cannot rely upon, we have a real problem. So yeah, I think Patrick has presented us with 2 alternatives. And you mentioned 67,000 and a little bit. Patrick, what is your advice on 17 days at 5,000 if we would choose to go that direction?
I think the board, that's how the board, when a reviewing, there aren't any particular standards that apply to actions in front of the boards with respect to the standards of proof before us. We're in those general administrative procedures. But when a case like this is appealed to a court, what they generally, the court is in some cases authorized to exercise its independent discretion, in which case the court looks to the weight of the evidence to support the findings. I think there's ambiguity in terms of how many days of violations there are, but 17 days is a reasonable total based on the weight of the evidence in front of the board. So I do think that an $85,000 penalty would be supported based on the fact that the evidence is inconclusive at best, but there is a strong showing that at least 17 days worth of violations at $5,000 per day, at a maximum penalty of $5,000 per day, occurred at this facility.
And there's certain ambiguity in the amount that possibly was discharged. That's
I feel that there's a lot of ambiguity with respect to those.
so. What is your pleasure?
Well, to me, Ms. Brock seems like a credible witness. I'm convinced that she signed based on her reliance on the engaged professional that she signed. So even though I know that that's an option for us as a board, I don't think that, given the circumstances, it's something that I would not direct the prosecution team to look into further, and that's my feeling. On that same token, I think that the prosecution team, is entitled to equally rely on the certified submissions prepared by the discharger and submitted to the state. The state can't be at every site investigating all discharges to see if they're accurate or not. So I think that their reliance on the report that was submitted is also justified. I find that Mr. Rogers' analysis as to the days is reasonable. I think it's based on an analysis of the evidence that was in our agenda packet. So based on that, I would support, the 17 days at $5,000 a day at $85,000. And I also would not recommend further inquiry into the miscertification by Ms. Brock. And that's how I feel at this time.
Well, my only comment is that the statement was made that the board needs competent data in order to make decisions, and the discharger has a responsibility to submit the accurate information in order for the decision to be made. That burden of proof is on the discharger, and I don't think that did come forth as the way it should have been. And I'm in agreement with the decision that Carmen had put forth.
Bob, do you want to weigh in on this? Okay. I'm looking for a motion. Carmen, you were first stated it. Can I get a motion out of you?
I move that we assess, let me go to my, I would move that the board issue an administrative civil liability order in the maximum amount based on 17 days of discharge at $5,000 a day for a total of $85,000, with a recommendation that no further prosecution of Ms. Brock or of the discharger be recommended.
Do I have a second?
I'll second that.
Carmen made the motion. Denise seconded.
We would have to edit the order to some degree to incorporate those changes. That would take a few minutes.
So
let me-
what's a few minutes?
To edit what? The statement about Ms. Brock or the dollar amount?
The dollar, both.
Okay.
The dollar amount as currently charged is $67,700. So we would have to change a few findings and add some language, basically saying that this order resolves the violations, any potential violations committed by staff of Brightburn in signing a penalty of perjury document, not rectifying that testimony, and any potential violations under 13.338.
Is 10 minutes enough?
Doctor, are you on the next item? Are you the attorney on the next item? Sac Regional?
We'll go
So-
ahead and continue this item and we'll bring it back after item 21.
There we go.
But we are going to take a 10-minute break, a 10-minute recess right now. And we'll be back 5 after, and then we'll bring this back after the next item to vote on it. To consider an amendment to the MPDS permit for the Sacramento Regional County Sanitation District's wastewater treatment plant in Sacramento County. Is there anyone present who is contesting the proposed actions and wishes to present evidence or testimony on the matter? Since there are persons present wishing to contest this item, we'll proceed with the hearing. This hearing will be conducted in accordance with the notice of public hearing and meeting procedures published with the meeting agenda. At this time, evidence should be introduced on whether the proposed action should be taken. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear the testimony you're about to give is the truth? If so, answer, I do. Thank you. The designated parties are Sacramento Regional County Sanitation District and the California Sport Fishing Protection Alliance. Total times allowed for testimony are as follows. Excuse me. Sacramento Regional County Sanitation District, 10 minutes. California Sport Fishing Protection Alliance, 10 minutes. And I saw no interested persons, but all other persons would be interested persons and would have to limit their testimony to 3 minutes, and a timer will be used. Please state your name, address, affiliation, and whether you've taken the oath before testifying. Does council have any legal issues to discuss at this time?
There is one legal issue, Dr. Longley, and it regards a comment letter received yesterday afternoon from US EPA, and Adam Lapitz will speak a little more to that comment letter.
Yes, Adam, please go ahead.
Yes, we received a comment letter from US EPA yesterday. The EPA did submit timely comments to this, and we responded to comments. In our response to comments, we tried to address EPA's comments, and in this letter, this email that was sent yesterday from EPA, they basically said that we addressed their comments, they felt that we complied with the CTR, and they were not going to contest the permit. I would like to have these comments admitted into the record. There's no new technical information, so that's...
We'll admit those into the record. Any other issues, council?
That's the only issue at this time.
Thank you. We'll now begin with testimony by staff.
Good afternoon, Chairman Longley and the members of the board. My name is Xuan Luo. I'm a staff engineer in the Sacramento office, and I have taken the oath. The next item for consideration is an NPDES permit amendment for the Sacramento Regional County Sanitation District, Sacramento Regional Wastewater Treatment Plant. The facility is located about 10 miles south of downtown Sacramento, as shown here by the red star. The facility discharges to the Sacramento River within the Sacramento-San Joaquin Delta and serves about 1.4 million people within the Sacramento region. The facility is permitted to discharge an average flow of 181 million gallons per day. The NPDES permit was adopted in December 2010 and requires major facility upgrades, including tertiary filtration to remove pathogen and nitrogen removal to reduce ammonia and nitrate. Following the permit renewal, Sacramento Regional County Sanitation District, known as the Discharger, and California Sports Fishing Protection Alliance, known as CSPA, filed petitions with the State Water Board. The State Water Board reviewed the permit and adopted a water quality order in December 2012 that for the most part upheld the permit with minimum...
Excuse me, could you slow down just a little bit so the court reporter can stay up with you?
Sorry about that.
Thank you.
The State Board reviewed the permit and adopted a water quality order in December 2012 that for the most part upheld the permit with minimum revision required. The discharger and the CSPA subsequently filed lawsuits with the Sacramento Superior Court. The litigation with the discharger has been resolved. Regarding the CSPA litigation in October 2014, the Superior Court for Sacramento County ordered the Central Valley Water Board to 1. Vacate the thermal plant exception in the permit, and reconsider the issue whether thermal plant exceptions may be granted. 2, vacate the portion of permit establishing effluent limitations
Please
for harness
slow down. Slow down.
for harness-dependent metals and recalculate such effluent limitations without using the harness value of the effluent. And 3, establish a weekly effluent limitation for aluminum. In the next few slides, I will talk about each of the items in the court order and how this permit amendment complies with the order. First item, thermal plant exceptions. The court found the regional board continued thermal plant exceptions from the previous permit without including proper finding. The court directed the regional board to vacate thermal plant exceptions and reconsider if thermal plant exceptions may be granted per federal regulations. Thermal plant is a water quality control plan for control of temperature in the coastal and interstate water and enclosed bay and estuaries of California. It contains temperature objectives for surface waters. The thermal plan allows regional boards to provide exceptions to specific water quality objectives as long as the exceptions comply with the Clean Water Act and federal regulations. The applicable exception in 40 CFR provides that thermal discharge effluent limitations or standard may be less stringent if the discharge demonstrates that such effluent limitations are more stringent than necessary. The proposed order continues the thermal plant exceptions from the 2010 permit and complies with the court order with proper finding for the exceptions. The findings including new temperature study conducted by the discharger to assess the thermal impacts of the discharge on aquatic life of Lower Sacramento River. The findings also have a detailed history of the consultation with the fishery agencies, including the National Marine Fisheries Service, the United States Fish and Wildlife Service, and the California Department of Fish and Wildlife. The proposed order states that the discharger has demonstrated effluent receiving water limitations based on the thermal plan are more stringent than necessary, and the thermal plan exceptions are sufficient to assure the protection and the propagation of a balanced indigenous community of shellfish, fish, and wildlife. The second item is effluent limitations for harness-dependent metals. The court found the regional board failed to properly use equations set forth in California Toxics Rule, known as CTR, for harness-dependent metal criteria, and used effluent harness rather than receiving water harness to calculate effluent limits for harness-dependent metals. The CTR contains water quality criteria for 7 metals that vary as a function of hardness. The metals include calcium, copper, chromium-3, lead, nickel, silver, and zinc. The lower the hardness, the lower the criteria. The criteria for hardness-dependent metals are based on hardness of receiving water, actual ambient hardness, as required by the state implementation policy, known as SIP, and the CTR. To comply with the court order, the proposed permit established criteria for hardness-dependent metals using CTR equation based on a 10-year record of receiving water hardness data measured upstream and downstream. This figure here shows the sampling locations of upstream receiving water, effluent, and downstream receiving water. Effluent limitations in this order were developed based on thorough analysis under reasonable worst-case ambient conditions. They're fully protective of beneficial uses and in compliance with the state and federal regulations and the court order. The last item is weekly effluent limitation for aluminum. The court found the regional board failed to establish a weekly effluent limitation for aluminum as required by federal regulations. To comply with the court order, the proposed permit include a weekly effluent limitation for aluminum. Public comments were received from the discharger, US EPA, and CISPA. The comments are mainly focused on thermal plant exceptions, CTR hardness-dependent metals, compliance with copper limitations, anti-degradation, and anti-backsliding. For thermal plan exceptions, CSPA comments that considering the current drought and cumulative impact of its thermal discharge, together with all other significant impacts on the species affected, the regional board cannot approve a thermal plan exception. Staff does not agree. As discussed earlier, the proposed permit complies with the court order and include proper finding for exceptions. Based on the studies of the discharger and consultation with fishery agencies, the proposed order states that the discharger has demonstrated that limitations based on thermal plan are more stringent than necessary, and the exceptions are protective, considering the cumulative impacts of the thermal discharge together with all other significant impacts. The permit also includes a reopener provision if additional information recommendations are provided by the fishery agency. The thermal plan exceptions are evaluated at each 5-year permit renewal, including the upcoming permit renewal early next year. For CTR harness-dependent metals, U.S. EPA is concerned that the harness value used to compute the copper limits its outside ambient harness value in downstream waters. Therefore, EPA requests clarification on how the approach for selecting harness value and the corresponding metal effluent limits are sufficient to meet CTR criteria and protect downstream waters. The regulation do not define whether the term ambient necessarily requires the consideration of upstream or downstream harness conditions. Upstream or downstream harness could be used. When sampled on the same day, monitoring data show that downstream harness is relatively the same as upstream harness. Therefore, staff consider harness upstream and downstream of the discharge to represent the ambient condition. Copper limits based on a harness of 84 or lower are protective under reasonable worst-case conditions. Copper limits based on harness higher than 84 are not protective. Therefore, staff finds that a hardness value of 84 milligrams per liter was appropriate to calculate a copper effluent limit that is protective under all ambient conditions. CSPA also comments that the proposed permit failed to identify and use the lowest sampled hardness data contrary to state and federal regulations. Staff does not agree. The selected hardness complies with federal regulations, state policies, and state board precedent. Using lowest ambient hardness value will result in more conservative effluent limits that are not needed to protect the beneficial uses, and yet result in substantial additional costs to the discharger and ratepayer. U.S. EPA comments that a compliance schedule for copper may be necessary as the performance-based average monthly value is above the proposed average monthly effluent limits. Staff does not agree. U.S. EPA mistakenly compared the daily performance value to the monthly limit. As shown here, the discharge's current performance is below the average monthly and maximum daily effluent limits included in the proposed permit. The discharger requests mixing zone for copper as there have been a slight upward trend in copper effluent concentration due to the drought and increased water conservation. Based on current facility performance, the discharger can meet the proposed effluent limitations without a mixing zone. However, staff agree that based on recent data, copper concentrations appear to be increasing. Drought and water conservation could cause the increases, but more information is needed to evaluate the situation. Therefore, staff will reevaluate the need for a mixing zone and dilution credit for copper in the upcoming permit renewal in early 2016. For anti-degradation and anti-backsliding, CSPA comments that the proposed order does not contain an adequate anti-degradation analysis and does not comply with federal anti-backsliding regulations. Staff does not agree. The proposed effluent limits for copper are essentially equivalent to the effluent limits adopted in the 2010 permit. The average monthly effluent limit is increased from 7.3 to 7.4 microgram per liter, an increase of only 0.1 microgram per liter. Consequently, the discharger's anti-degradation analysis for the 2010 permit renewal is applicable to this minimum increase. Staff finds that any lowering of water quality will be de minimis and will accommodate important economic or social development in the Sacramento area. As for anti-backsliding, Clean Water Act allows a less stringent effluent limitation if new information is available. The revised effluent limitation are based on updated receiving water hardness since adoption of the 2010 order. The new receiving water hardness data submitted by the discharger is considered new information. Furthermore, the Clean Water Act provides an exception to the anti-backsliding regulations if the change is in compliance with anti-degradation requirements. As discussed in the previous slide, the change is in compliance with anti-degradation requirements, therefore anti-backsliding exceptions also applies. Later revisions are proposed to provide clarification in the fact sheet of the proposed amendment, in the response to comments document, and the above sheet. The proposed change do not modify any permit requirements. This concludes my presentation. Staff recommends adoption of the proposed NPDES permit amendment with the late revisions. Staff would like to enter this presentation, the agenda package, and board files for this facility into the record. Thank you.
Thank you. Any questions or comments by board members? Seeing none, I call now for testimony by Sacramento Regional County Sanitation District.
Good afternoon, Chair Longley and members of the board. My name is Prabhakar Somawarapu. I'm watching to make sure that you have it. Let me spell it. P as in Paul, R-A, B as in boy, H-A-K-A-R. S as in Sam, O-M-A, V as in Victor, A-R-A, P as in Paul, U. District Engineer for Sacramento Regional County Sanitation District. I've taken the oath. I don't have a lot of presentation here. I just wanted to thank the staff for working with the district in reaching to a sensible place where we are today. And I also want to let you know this is a permit that allows us to continue with the $2 billion upgrade that we're currently doing. It helps us to retain our focus on that effort as opposed to taking on and doing it, on placing it at a different place. Anyway, that's all I wanted to say. I appreciate the staff's work on this.
Thank you very much. Any questions?
No, but I would say that I did get a chance to tour the facility and the technology and the kinds of upgrades that you're doing and the quality of people that are at your facility are impressive. So I was glad to see that that this item was on our agenda today.
I appreciate the kind comments, and we have the trucks rolling. That the place is looking every day entirely different than the place I have come to see the last 20 years. But in the next 5-6 years, I think it'll look entirely different.
You're doing a good job.
Thank you, appreciate it.
And John Abely represented us at the ribbon cutting, I believe.
Yes, he's done a wonderful job.
Pamela and I were at a groundwater function we had to attend, and we were sorry that we missed your ceremony because that was a real milestone.
Well, since you called me out, again, everything about that plan and that I saw looked professional, and I just wanted to point that out, that it takes two to make these things work, and we really appreciate your efforts.
I think that likewise, we appreciate the support that the board has given. We've come a long ways in where we are, and we need to focus the next 5-6 years. I think that's what we have our eye on the end, and we want to keep that eye there. Thank you.
Thank you very much. I have a call for testimony by California Sport Fishing Protection Alliance.
Good afternoon, Mr. Chairman, board members. I'm Richard McHenry. I'm a civil engineer. I'm here today representing California Sports Fishing Protection Alliance, and I have taken the oath. As staff showed you, the Sacramento Regional Wastewater Treatment Plant discharges treated domestic wastewater to the Sacramento River at Freeport, which is just downstream from the city of Sacramento. We're here to really discuss, or I'm going to just briefly discuss two issues today. One is the thermal plan exception, and then even more brief comments on hardness-dependent toxic metals. As staff showed you, the thermal plan exceptions must be done in accordance with federal regulations, and they cited 40 CFR 125.73A, and that allows for thermal plan exceptions, as staff said, provided that it will assure protection and propagation of a balanced indigenous community of shellfish, fish, and wildlife in and on the water into which the discharge is made. Addressing recent temperatures in the Sacramento River, we submitted several citations. Actually, I first heard this on NPR one day, after not too long ago, I guess at the beginning of summer, where they were interviewing Stafford Lair, who's the California Department of Fish and Wildlife's chief of fisheries. And Fish and Game decided that they were going to actually have to close the hatcheries because the water was too hot, and they were going to truck the fish, the salmon, from especially the American River hatchery down to San Francisco Bay, because they said the Sacramento River was too hot, that they wouldn't survive. Actually, in quoting Stafford from the Sacramento Bee, and there were actually several articles in the Bee about this, the Bee said, Lair says the drought killed off nearly every single endangered winter run Chinook salmon in the state last year. The San Joaquin and Sacramento rivers, where they spawn, are shallower. They're warmer. They're too warm for the fish to thrive. Conditions were even worse this year, end quote. So, as I mentioned, as a result of those high temperatures, Fish and Wildlife decided to actually truck and close the hatchery because the water was too warm in the Sacramento River. So just based on this information alone, I would think that one has to conclude that Sacramento is not capable currently under these conditions of supporting a healthy and balanced population of fish, especially in terms of temperature. If this is the case, how can a conclusion be reached that allowing for even higher temperature discharges from the wastewater treatment plant would not actually contribute to making the situation worse? The decline in salmon populations is pretty well documented, and that's really what we've been talking about thus far with the Fish and Wildlife Service. But we haven't really talked about Delta smelt. Delta smelt are a federally threatened species, and they're also a candidate for endangered status. According to the Fish and Wildlife Service, a letter to the regional board in October of 2010, the majority of Delta smelt occupy the portion of the Sacramento River from Suisun Bay and the marsh to about the city of Sacramento. The declining populations of Delta smelt led to the federal listing in 1993, and Fish and Wildlife Service feels that the critical habitat for the Delta smelt in the Sacramento River extends northward up until the American River. So certainly the discharge from the Sac Regional wastewater treatment plant is in that range. Adult Delta smelt can be expected to be in the river generally from about December through June, and larval stage smelt essentially from February through June. Spawning is expected to increase in the main channel of the Sacramento River, especially during periods of low flow and other channels off the main water body. The U.S. Fish and Wildlife surveys in 2014 showed smelt populations have declined by 95.4% since the year 2000. And this year's survey shows that only between 1 and 6 individual fish were actually collected, which is the lowest that have ever been sampled. Delta smelt spawn in temperatures ranging from 59 to 68 degrees Fahrenheit. Temperatures above 77 degrees Fahrenheit have actually been shown to be lethal to smelt. And actually, during this period of drought, in the early summer months and recently, there have been numerous recorded temperatures in the Sacramento River at Freeport above 77 degrees or above that lethal temperature for Delta smelt. Of course, a river stratifies temperatures, and you would expect that the smelt might find some thermal refuge in the deeper waters, but this is exactly where the diffuser from the sewage treatment plant with a higher temperature waste is. It's in the bottom, so that certainly minimizes that thermal refuge. Talk about consultation between the fisheries agencies, and actually I appreciate staff's cooperation. They provided us with all of the comment letters, and they did so in a very timely manner, and were very nice to work with, so it's appreciated. But we didn't know what that consultation meant. Did that mean that the fisheries agencies actually concurred with the conclusions of the report? And actually, we couldn't find that it does. First, there are no comment letters from California Fish and Wildlife. They didn't comment at all, although I think I could take their Sacramento Bee quotes about the river being too hot. Well, you can take that for whatever it's worth. And I think the late revisions that you have before you by staff say that the Fish and Wildlife Service is going to submit comments on the thermal plan report, somewhere down the road. National Marine Fisheries repeated continuously in their comments that this is only based on 1 year's worth of data, so we don't know what the future is going to bring based on this report. So I couldn't really find that, yes, there's consultation, but I don't know that that means concurrence. With regard to hardness-dependent metals, the drought has its impacts here as well. Flow reductions from Lake Shasta brings an increased importance on discharges from the American River. I think it had been reported at some points in time that the flow at Sacramento was almost 40% American River water. And this is relevant to this issue because that water is significantly lower in hardness. And so, that's all I wanted to add at that. The rest of our comments, I think, are pretty well documented in our written comments. I'd be happy to answer any questions.
Any questions for Mr. McHenry?
Thank you.
Seeing none, thank you very much. I don't have any cards for any interested persons. Anybody here wishing to comment on this? If not, moving on, Mr. McHenry, do you have a closing statement? You have a couple seconds, I think. Thank you very much. Is there a closing statement by Sacramento Regional Sanitation District? Thank you very much. Closing statement by staff?
Yes, Dr. Longley. This amendment you have before you, just to give you a little context around this, we had originally asked the court to allow us to do these amendments as part of the permit renewal, which would have given us more time and data to consider as part of that permit renewal. And this was something that we had asked for, and we weren't granted that time, and we were required to do this amendment in July of this year and make these changes. And so some of the comments that you hear about the thermal plan and U.S. Fish and Wildlife not being able to, we have consulted with them, but they haven't been able to provide a full review of the thermal plan report because they haven't had the time to do so. So we've proceeded the best we can with the best information we have, and considering the record, considering the exception for the same limitation or the same changes was approved in 2010, and U.S. Fish and Wildlife was okay with it then. We're not doing anything that is any different than what was okayed back in 2010. And also, National Marine Fisheries Service has reviewed and approved this, I concurred with this granting of this exception. So we've moved forward the best we can. Would we have liked more data considering the drought? Would we have liked more information? Yes, especially as this unprecedented drought, the entire system's stressed. We're looking at emergency change petitions from water rights where they're unable to release as much cold water from reservoirs and things like that. And so it is a difficult situation we're in, and we hope to get more rain. That was, I guess, the first comment that I had and I wanted to address. One other important thing to keep in mind while you're thinking about this is we're not required to have concurrence from the fisheries agencies on granting the thermal plan exception. That's not a requirement. We like to have it, but it's something that's not statutorily required. So, with that.
Thank you very much, and I presume if new data indicates that changes need to be made, you'll bring this back to the board.
Yes, in this we are working full bore to get this before the board in February. And that exactly when we get the more information in front of us, we will certainly make the changes that need to be made.
Very good. Recommendation from the executive officer.
Dr. Longley, I support staff's recommendations for this. Do we have any late revisions or anything?
We do not have any late revisions.
No edits at all.
We have some late revisions that you have before you.
Okay.
Most of them are clarifications. Okay. We tried to respond to the comments, provide clarification on how we calculated the hardness for US EPA and things like that.
Okay. So with that, I do want to remind the board that this is just an amendment, that we do have the complete report of waste discharge in our office that we're reviewing for renewal for 2016. Or no, we don't have the report of waste discharge. We do have it. So this is just
an interim measure.
Something we need to do to meet the court order to make
right.
the appropriate findings in the document for the
right.
thermal plan exceptions and better address the hardness issues. So some of these questions that you may have about the thermal plan and some of those questions will be resolved through the permit renewal that will take place in 2016.
Great.
So I recommend the board adopt this amendment with the proposed changes.
Great. We'll close the hearing and I'll entertain a motion for discussion.
I would say that, I appreciate what Mr. Lappet said, that this is, what we need to do to comply, and certainly there's room for improvement and the commitment to bring it back to revisit these issues. But I think given the court order and the findings that were presented today, I would move that we approve it with the late revisions.
I'm going to second that. I just want to touch on a few things. The U.S. Fish and Wildlife Service plans to review the temperature study in more detail and may provide additional recommendations during the upcoming permit renewal scheduled for early 2016. And I think that's goes back to the fact that we all would like to have had a little more time to properly review or to additionally review all this information. I also want to just touch on Sacramento Sanitation and the work they've done and the commitment they've made to improving water quality in the Sacramento River, particularly with respect to ammonia, and that's not an easy effort, and I appreciate that. The comments about the temperature of the Sacramento River, we all know all that. I don't for a minute really think that the city of Sacramento is a major contributor in this case to the issues that I hold dearly with respect to salmon and Delta smelt and the other fish. That is a product of a major drought. It's a product of a dysfunctional water rights situation in some respects. Our issue is to try and do the best thing we can to enhance and improve and maintain water quality, and I think our staff in this case has done the absolutely best job they can under the time constraints that the court's put on us. So I support this, and I'm going to vote yes, and I seconded it.
Yeah, and Bob, I concur entirely with your comments. The heat load to that river by Mother Nature is extremely significant, and in fact, if we didn't have upstream storage, if we had in total natural conditions as occurred before Shasta was built, and the dams that followed, the situation would be even worse. So I fully support this. And do I have any further comments? If not, I'll ask for the roll call vote. And the understanding is that motion and second was included the late revisions. Make that clear. Very good. Roll call, please.
Ms. Ramirez? Mr. Costantino? Mr. Schneider? Ms. Cadara? Dr. Longley?
Aye.
Motion carries.
Thank you. So with that said, we will go back to item number 20 on the agenda. The hearing is closed, and we are discussing, we have a motion and we have a second, and our legal counsel was putting together the language that we were going to vote on.
Yeah, just give me 1 minute to upload this to the drive so it can be in front of you. I haven't printed out copies yet. Just
We're
finished.
doing this on the fly, right?
Yeah.
Well, I'll take the time while you're uploading that. Quite frankly, I support the motion and the second. I believe that this was one of the two alternatives I pointed out, and that was simply sloppy reporting. But as was pointed out, we rely on the data that's reported, and we cannot really tolerate anything less than real strict attention paid to getting us the best of data that one possibly can put together. I think that this board has expressed its concern about what happened, and we're ready to vote once we see the item.
Dr. Longley, if I had just state that, for the discharger that's here, I would just like for them to know that I think that their counsel did a good job of bringing forth their argument as far as, discharge in the wells and the evidentiary, issues that they had to prove. And you know, if I made my motion based on the 17 days proposed by Mr. Rogers, but if the only evidence we had before us was only the wells, I think that council raised enough issues that I don't know that all the evidence would have been there for me to make the same motion. So I think that council did a good job for their client, and yeah, that's all I'll say.
Well, basically, I concur with you, but I think I think that in the future, if I see something like this, I'm going to be suggesting to our council and the executive officer that they investigate it more thoroughly along the lines of the other alternatives that that our council suggested, rather than bring something like this to us. Where did Patrick go?
Here.
They're getting there. I do know to speak into the mic by now. The administrative civil liability order has some edits that frankly turn it into an administrative civil liability order as opposed to a settlement. It's just how it was initially styled. I'll walk you through the most significant portions.
Has this been made available to the discharger yet, or no?
No.
Okay, all right.
First, in regulatory considerations, or in the first finding responding to the 16 July 2014 report, we note that the initial report submitted by the discharger was inaccurate and the discharger discharged treatment fluids, and it goes on as written. Finding number 6 is inserted. At the public hearing, the discharger once again contradicted previous submittals that were required by board orders issued pursuant to Water Code Section 13267. Discharger stated that it actually only discharged fracking fluids to 2 unlined sumps and that it had known this information for some time. The discharger made these statements based on a reinterpretation of materials that it had previously analyzed, but failed to provide firsthand evidence that this was in fact true. And I think that reflects the nature of the evidence that was before you today. I quote Water Code Section 13268, which is the potential $1,000 per day violation for submitting deficient reports to the board. Adding a finding stating the Central Valley Water Board finds, based on evidence submitted in this matter, that there are material deficiencies in the responses that the discharger has submitted in response to the Water Code Section 13267 orders that required the discharger to submit reports detailing activities that may have resulted in discharges to waters of the state. Furthermore, these deficiencies have resulted in inaccurate or vague descriptions of the unauthorized discharges to waters of the state committed by the discharger and obfuscated the nature and extent of these discharges. Another finding, the Central Valley Water Board finds, in light of the conflicting testimony and evidence, that the discharger discharged waste to at least 2 and possibly as many as 6 unlined sumps without a permit. These wastes were likely discharged over a period of 17 days, although waste materials may have remained in unlined sumps for a period much longer than that. Though the discharger has contradicted these statements, the weight of the evidence indicates that these discharges occurred over 17 days. This is crossed out stuff pertaining to a settlement. Couple corrections here, and adding a finding that Board Member Ramirez requested. This order resolves violations that may have occurred as a result of the discharger's submittal of deficient reports signed under penalty of perjury. Should this order be overturned by either the State Water Board or a court of competent jurisdiction, the Central Valley Water Board has the discretion to pursue enforcement of any administrative, civil, or criminal remedies that it has the legal authority to pursue for these potential violations, essentially saying this wraps it up unless it's overturned. Hereby ordered that, here's the kicker, of $85,000, adding the petition language and turning it into an order signed by Pamela representing that it was an order issued by the board. Waste discharge permit fund. I will check into that. Attachment A is largely the same, except it adds the fluid was likely discharged. And this adds the sentence under Factor 2. The Central Valley Water Board issued a subsequent 13267 order to the discharger when the discharger's initial submittal failed to contain sufficient information to ascertain the nature and extent of the alleged discharges. The discharger's 16 July 2014 technical report submitted in response to the second 13267 order. That's just clarifying that there was a process of two orders that came in to the discharger. And lastly, the other factors as justice may require, step 7 is modified to say the proposed liability assessment of $85,000 reflects a resolution based on the uncertainty of a number of factors, including material deficiencies in several of the discharger's responses to 13267 orders issued by the Central Valley Water Board. It goes on to X out the statement of the definitive nature of the discharge and instead say the discharger's response to subsequent orders was contradicted by the discharger's own statements at the board hearing. And lastly, this is delete agreed upon. The administrative civil liability is $85,000. This significantly exceeds the assumed economic benefit plus 10%. It's a requirement of the policy. And the final liability amount, based on the deficiencies in the discharger's submittals and certain evidentiary uncertainties, the final assessment shall be $85,000.
Any questions from board members regarding? Yes.
No, I think this reflects precisely what I had hoped to achieve when I made my motion.
Good, thank you. Any further comments?
I will, for the record, I had to step off the dais for a considerable length of time, and this final document is substantially different, even though I had read the materials and only listened to some of the testimony. I will need to abstain from this vote.
Very good. Call the roll, please.
Add one clarification. I'm not sure whether this goes to the water pollution cleanup and abatement account or waste discharge permit fund. Different penalty assessments go to different places. Minor modification to this order should be allowed to specify a different fund if statutorily it requires to go somewhere else.
And which one would that be? Say again, please.
It's either the cleanup and abatement account or the
Okay.
waste discharge permit fund. I can't quite think of it off the top of my head. It's been
And
a long couple days.
And I would amend my motion to allow for that kind of flexibility given the findings of our council.
I second that.
And Denise concurs. Okay. Call the roll.
Mr. Schneider? Ms. Ramirez? Mr. Cosentino? Ms. Cordova?
Yes.
Dr. Longley?
Yes.
Motion carries.
Thank you very much. We now go to the final agenda item of the day. Item number, no, we don't. Yes, we do. Item number 23. At this time, we'll receive an update on the Irrigated Lands Regulatory Program. This is an information item only and no action will be taken. Although the board may ask questions and provide direction to staff. Following the staff presentation, interested parties will be allowed 3 minutes each to address the board. We'll now hear the staff presentation.
Good afternoon, Dr. Longley, members of the board. I'm Sue McConnell, the Program Manager for the Irrigated Lands Regulatory Program, and I'm here to introduce the last item of the day. So it's a three-part information item for the Irrigated Lands Program. Brett Stevens, our Chief of our Compliance and Outreach Unit, will start out with an enforcement update. He will describe the status of enforcement actions in the coalitions, talk a little bit about the enforcement backlog, and provide recommendations for addressing that backlog. The enforcement activities he'll discuss include both non-filers, which are growers who haven't enrolled in our program, and non-compliance with our general orders. After Brett, I will come back and continue our discussion on disadvantaged communities that we started in June, at the June information item, and answer the question you had, which is, once we identify those communities, what happens then? After that discussion, Glenn Meeks, our senior engineering geologist, will discuss the general orders requirements for coalitions to identify high vulnerability areas and some of the issues that have come up as a part of that identification and our current staff approach for addressing those issues. So with all three items, we're looking for board feedback on staff recommendations. And with that, I'm going to turn it over to Brett to talk about enforcement issues.
Right before you start, I'll just congratulate everybody who's still in the room. It's a lot thinner than it was earlier in the day.
I'd like to make it thinner and,
Good afternoon, Chair Longley, members of the board. Like Sue said, my name is Brett Stevens, and I'm a senior scientist working in the Irrigated Lands Program. I'm here to provide you with an update on the ILRP's enforcement activities and to ask for your direction regarding board staff's plans for future enforcement. The topics I'll discuss include an overview of the Irrigated Lands Program general orders and how they have affected grower outreach and enforcement. I'll also discuss board staff's grower outreach process and provide the Irrigated Lands Program's current enforcement backlog and an estimate of the future backlog. And I'll close with some recommendations for reducing this backlog. The Irrigated Lands Program is in the midst of a large grower outreach effort brought on by board approval of 8 Irrigated Lands General Orders. The East San Joaquin General Order was the first approved by this board with an approval date of December 2012. The East San Joaquin watershed is shown outlined in red on the figure. This figure also shows the boundaries of the 14 grower coalitions located within the Central Valley. With the passage of the East San Joaquin and other general orders, the Water Board began regulating waste discharges to groundwater. This created the need to outreach to a large number of growers who were previously exempted from the Irrigated Lands Program. The first non-participant related enforcement cases in the East San Joaquin watershed began in October 2013, and numerous East San Joaquin enforcement cases have already been resolved. However, the current enforcement case backlog in this area is 51. The general order for the Turtle Lake Basin area was approved in January 2013. This area is outlined in red on the figure. Unlike the areas covered by other general orders, the Tulare Lake Basin area is divided into 7 grower coalitions. Staff enforcement is underway for growers in this area with 29 enforcement cases pending. The Tulare Lake Basin area has much grower outreach remaining, and it is expected to create a significant number of non-participant related enforcement cases. The general order for the Western San Joaquin River watershed was approved in January 2014. This coalition area has a high level of grower compliance because the coalition is comprised of irrigation water districts that can require coalition membership as a condition of water delivery. There are currently 3 enforcement cases pending in this coalition area. The general order for the western Tulare Lake Basin area was also approved in January 2014. As with the western San Joaquin River watershed area, the western Tulare area has a higher grower compliance rate because the coalition serving this area is also a regional water district. No enforcement cases are pending for this coalition area. The Delta General Order was approved in March 2014. The first enforcement cases for this area are anticipated in December 2015. There is still significant grower outreach to be done in the Delta Coalition area, and this area could potentially create a large number of enforcement cases. The General Order for the Sacramento Valley was approved in March 2014, and the first enforcement cases for this area are anticipated in October 2015. The Sacramento Valley is a large area with tens of thousands of acres of unpermitted irrigated lands. This area is therefore expected to create a significant number of non-participant related enforcement cases. This figure shows the timelines for the general orders I've just reviewed. The green portion of the arrows shows when the order was adopted. The blue portion shows when the notices of applicability were issued. The purple shows the open enrollment periods. This was a period of about 3 months for each order when growers could enroll directly with the coalition without submitting an application or fee to the water board. The yellow portion of the arrow shows the compliance and outreach time leading up to the formal enforcement, and the red shows when enforcement began or will begin, depending on the coalition area. There are general orders that are not included in this figure. Timelines for the rice general order, the grasslands drainage area order, and the general order for growers who are not part of a coalition are not shown, as these orders are not anticipated to create non-participant related enforcement cases. This figure shows how the timelines for the various coalition areas compare. The earlier schedules for the East San Joaquin watershed and Tulare Lake Basin area are shown. These earlier schedules explain why these 2 coalition areas already have significant enforcement caseloads. I'm now going to briefly review staff's grower outreach process to explain the main origin of irrigated lands enforcement cases and to show that staff has tried to use enforcement as the means of last resort for obtaining grower compliance. To identify likely owners of commercial irrigated lands, staff relies on the California Department of Conservation's Farmland Mapping and Monitoring Program. This agency produces a map of Central Valley agricultural lands that staff uses along with county zoning records to identify these landowners. The landowners' parcels are then vetted to remove lands permitted by the Dairy General Order and lands already enrolled with coalition. After identifying likely owners of irrigated lands, staff next send out new regulation notification letters to landowners. Over 30,000 of these letters were sent. The letters explain that the Irrigated Lands Program now includes regulation of waste discharges to land, and that consequently all commercial irrigated lands in the Central Valley would require regulatory coverage. The letters also invited landowners to enroll their irrigated acreage during the open enrollment period when regulatory requirements would be simpler and less expensive. Of the landowners who received an outreach letter, 40 to 60% joined their local coalition, depending on the general order area. And thus the outreach letter mail out was a cost-effective means of enrolling a large number of growers in the Irrigated Lands Program. After the outreach letters were mailed, staff began inspecting the parcels of landowners who did not respond to the letters. Parcel inspections began in May 2013 and are ongoing throughout the Central Valley. Most inspections are done in the field, but sometimes remote inspections are done using aerial images. Irrigated land staff strives to conduct field inspections at least monthly, which gives staff a field presence and allows them to check local waterways for agriculture-related waste discharges. The results of the inspections have been that about 3/4 of parcels inspected are commercial irrigated lands that require regulatory coverage. For those parcels with evidence of commercial irrigated land use, the Assistant Executive Officer issues Water Code Section 13260 directives, thus informing the landowners of the requirement to get regulatory coverage for their discharges. Landowners are given 15 calendar days to respond to the directive by submitting a notice of intent to the board to get regulatory coverage. Landowners who do not respond are issued notices of violation and given 15 calendar days to respond to the NOV. Landowners who do not respond to the NOV become eligible for formal enforcement. This figure provides an irrigated lands outreach and enforcement summary, and it shows how the State Board enforcement policy applies to the irrigated lands program. In addition to the steps below the dotted red line, which I've just reviewed, this figure shows the formal enforcement steps of issuing pre-administrative civil liability notification letters and ACL complaints. Before we pursue formal enforcement, we also try to reach the grower by phone, which is shown as the last chance phone call on the figure. This is something that the board has requested that staff do, so we've added it to our process. The purpose of this figure is then to show the relationship between the various outreach and enforcement steps, and to show that the irrigated lands staff has attempted to comply with the State Board enforcement policy and to give growers ample opportunities to comply with the program. Now that the irrigated lands outreach and enforcement process has been reviewed, I'll discuss the enforcement backlog and staff recommendations for managing it. The Water Board's Rancho Cordova office currently has 54 enforcement cases waiting to be resolved, and the Fresno office has an enforcement case backlog of 29. The ratio of directives issued to the current enforcement cases indicates that about 10% of directives will lead to enforcement cases. The Irrigated Lands Program work plan for the current fiscal year calls for 900 to 1,000 directives to be mailed. This rate of directive mailouts will yield an estimated 90 to 100 new enforcement cases per fiscal year for the foreseeable future. A substantial amount of staff time will be needed to process current and future enforcement cases.
So Brett, can I interrupt you
Sure.
there? So how are you defining backlog? Is that a pending enforcement act, or is that a late, or is there a time limit? Or?
Those are growers who have received a directive and an NOV and haven't responded.
Oh, so it's not a backlog on our staffing issues yet?
Well,
It's a-
Mr. Constantino, it is a backlog in that those are NOVs that are sitting out there that we haven't had a chance to address yet, that we haven't gone any further with.
Okay.
Oh, I can't, oh, there I go. I believe all the NOVs are entered into the database?
Yes.
And so that's tracked publicly. People can look at it. So, and the Office of Enforcement tracks that in their reporting every year to say how efficient we are at addressing our enforcement actions. So it is a backlog, and it is something we have to address because it's a report that's made at the end of the year by the Office of Enforcement.
But there's no, as soon as that gets put in the database, it's a backlog automatically? Or is there a 30-day or 90-day window for us to
I don't think the
address?
enforcement policy puts a timeline on NOVs, but I don't know. Brett, you said it was a backlog, or you need to define what you mean by a backlog.
I mean that these are growers who are eligible for formal enforcement because they've received the directive and the NOV and not responded.
Okay.
In addition to enforcement related to non-participant outreach, enforcement cases may be created by general order compliance inspections and by coalition members' failure to submit farm evaluations to the coalitions. The order compliance inspections will be conducted at farm sites with a focus on evidence of irrigation water or stormwater waste discharges, erosion and sediment controls, the presence and adequacy of the farm evaluation and nitrogen management plan, and adequate wellhead protection for any irrigation supply wells on site. Board staff has allocated time to conduct order compliance inspections this fiscal year. As the workload associated with non-participant outreach and enforcement recedes, staff will direct more resources toward order compliance inspections. Given that the irrigated lands enforcement backlog is significant and bound to grow, there is a need to increase enforcement case processing. Staff has resolved several cases in the last 2 years, some through negotiation and some before this board. The board's decisions in these latter cases have provided staff insight and guidance for resolving future cases. In order to increase enforcement case processing, staff proposes that we resume the use of pre-administrative civil liability notification letters and that we schedule special hearing panels dedicated to hearing large blocks of irrigated lands enforcement cases. Pre-ACL letters are an optional first step in the formal enforcement process that give growers the opportunity to negotiate a settlement before an ACL complaint has been issued. These letters have been used in the past for irrigated lands enforcement cases, but their use was put on hold in July 2014. At that time, the advisory team to the board raised concerns about 2 proposed settlements to enforcement cases and requested that the settlements be considered at a board hearing. Since that time, 4 irrigated lands cases have been decided by the board, and through these cases, the board has provided enough direction to staff for us to reach successful settlements with growers. We hope. Issuing pre-ACL letters provides several advantages to the enforcement process. The letters are much easier to prepare than ACL complaints, and if settlement is reached, the settlement order is also a simpler document to prepare than an ACL complaint. Pre-ACL letters are often lead to settlement without going to hearing, which reduces the burden on staff's time and the board members' time. These letters also provide growers with another opportunity to claim a program exemption or that they would struggle to pay a proposed fine. These types of claims are easier to investigate and resolve at the pre-ACL step before an ACL complaint has been issued. Growers who don't respond to the pre-ACL letters or who can't reach settlement with staff receive an ACL complaint. Hearing panels may also help irrigated land staff reduce the enforcement case backlog. Staff's understanding is that these panels allow for several cases to be heard by 2 to 3 board members at a special hearing outside of regularly scheduled hearings. Decisions made by the hearing panel are then presented to a board quorum for approval by the full board. Thus, the hearing panel should reduce the burden on regular hearings and increase the rate of enforcement case processing. Irrigated land staff consulted with dairy program staff who advised that the hearing panels were useful in their experience. The main irrigated lands enforcement backlog is related to non-participants, but if we get a lot of enforcement cases related to failure to submit a farm evaluation plan, hearing panels could be used in these cases as well.
And if I may interrupt at this point, I was around participated on the dairy hearing panels. As I recall the process, the panel heard and obviously came up with a recommendation. When it came to this board and was heard here, those moved very quickly. The board does not have to revisit unless a board member wants to revisit the total case. Am I correct?
Defer to Patrick.
Absolutely. What happens is the hearing panel hears the case, hears the evidence, hence the hearing panel name, and then writes up a recommendation for the full board. The full board deliberates on that recommendation and does not need to reopen a hearing to collect more evidence. So these can be dealt with in a fairly streamlined fashion.
But if a board member feels uncomfortable with that report or wants additional information, can ask for that. Am I correct?
Absolutely, or they can decline to issue based on the recommendation
Right.
of the hearing
Good.
panel.
Thank you.
I have a question. I know this is just in the early stages of this design, but how does that work with quorum issues? Would the panel not be able to discuss it with the non-panel members, or how's that work?
It is a bit odd procedurally. The non-panel members would solely be debating on the recommendation to the rest of the board. That debate would occur not necessarily for quorum issues, but because of Bagley-Keene noticing, that discussion would occur in open session. So essentially, you'd have 2 board members who would, or possibly 3, defending what they heard in the hearing panel and their recommendation to the board. Now, as Dr. Longley will probably tell you, for the board members that participate in the hearing panel, it is like participating in a separate hearing. So all the other board members would have to buy them coffee the day of the hearing or something like that to compensate for going through the whole extra process for that.
I was thinking donuts, but okay.
Both are warranted.
So the main enforcement-related conclusions I'd like to leave you with are that outreach to growers lacking regulatory coverage in the East San Joaquin River watershed, the Delta, the Sacramento Valley, and the Tulare Lake Basin area will create a large enforcement case backlog over the next few years. General order compliance inspections and grower failure to submit farm evaluations may also create a large number of enforcement cases. The recent rate of processing enforcement cases has not been adequate to timely process the case backlog, so new procedures are needed to increase the rate of enforcement case processing. And finally, it is in the Irrigated Lands Program's interest to timely process enforcement cases. Failure to do so will undermine the morale of current coalition members and potentially threaten the viability of the coalitions themselves.
Once again, Carl Longley, that's a very good point. Some time ago when I attended a meeting of the board for the East San Joaquin Coalition, those board members made it very clear to me that it was essential that this board have a program such as this because of the morale issue, because they felt it was unfair that some paid and some didn't pay. You know, that was the general tenor of what was told to me. So from the boards, from the coalition board standpoint, they were looking to this board to stand up and take action such as this.
Based on these conclusions, staff's recommendations for managing the enforcement case backlog are to resume the use of pre-ACL notification letters and to schedule special hearing panels to resolve irrigated lands enforcement cases in large batches. These are staff's recommendations, and we welcome board guidance and direction on our enforcement plans.
John?
So, can you go back one slide?
Sure.
So, maybe I'm missing something, but resume the use of pre-ACL, does that mean there's a hold?
Not officially.
There was never a hold. They interpreted our request to have a couple of the ACLs for the non-filers under the new order to come to the board, for the board to weigh in and give guidance to staff as somehow we were telling them to stop. And so it was just not well communicated between the advisory side and the prosecution side.
When we issue a pre-ACL letter, we're inviting the grower to negotiate and reach a settlement. We had to have enough information gathered from the board's decisions to be confident we could come up with a settlement without it getting kicked back to us again. So we did kind of put it on hold ourselves, but we're planning to resume the use of these letters, and we would just like the board to affirm that plan.
And I should say that we have resumed the use of those letters, and in fact, we have 2 tentative settlements as a result of those. So they'll be going to the advisory team to look at.
Okay, I have a couple of questions I wrote down.
Sure, go ahead.
Can we go back to slide 10? Maybe I missed it. The cross-hatching on the Tulare Lake Basin, was that because it was?
That's because they have more than one coalition. So their open enrollment times fluctuated.
Oh, okay. And then on slide 15, are those actual numbers?
They are,
okay.
Yes.
And then the next question, I have a resource question, but I'll probably keep that for later. But and then a priority question, I guess, is every one of these NOVs or non-responsive farmers equal, or is a much bigger farm or the size of the, I mean, how are we prioritizing high vulnerability areas, size, anything like that, or are we just, is everybody equal?
To this point, we've been prioritizing based on size and crop type. So basically, we've been trying to prioritize based on what we know about the crop value. And so dischargers who look like they have a higher crop value based on what they're growing has been where we've prioritized, although we also want to, in terms of making sure that everyone is treated equally, look at smaller growers and look at a wider range as we are able to sort of expand the process that Brett was talking about.
So I hate to ask the question, but the settlements aren't based on crop value, or are they?
The settlements are, I mean, they're based on the enforcement policy and the factors as we interpret. One of the factors, which I think, I won't talk about the settlements, but in terms of some of the cases that the board heard, one of the factors is sort of the potential for harm. Larger operations are seen as having a higher potential for harm.
Sure.
And then it also goes into some of the economic considerations as well.
Okay. And then maybe the coalitions, they don't have any role. I know we had a whole discussion about them being our surrogate law enforcement. And so I just want to ask, is there any role in this whole process for the coalitions, or once they're done putting their request in and trying to seek, I mean, I know that they have an active role, but not once we get to this enforcement stage.
Their main role is providing information. We would check in with them periodically to see if some of our ACL candidates have already enrolled.
Yeah, I think we should clarify, they don't play a law enforcement or a regulatory role, the coalitions.
That's correct.
I had a question. In the letters that go out, from the initial letters to the final outreach letters, does it spell out in those couple of letters that go out what are the penalties for if non-compliance, or is that too early, or when you get up to the notice of violations, that's where it's spelled out?
There's a water code citation in the letters that gives a per day maximum fine amount. We can provide you a copy of that letter if you'd like one.
It's pretty clear. They look very legal. They've got large black in bold notices telling them you must read this and comply. It's really pretty clear.
Okay.
That
you're
they're
friendly,
getting,
and then at a point you put the information there.
yeah,
where they
it's I wouldn't call them friendly.
Okay.
But
Yeah, I'm sorry.
they're very clear.
Okay.
Yeah.
Okay.
But the discharger might not know what kind of violation they're facing. If they're looking at 3,000 or 80,000, they're
Well,
not going to know that.
It does say $1,000 a day, but that's until we have a case. There's no way that we could give them. Although maybe we can consider putting some in a sidebar what current ACLs were for non-filers, so they're on. Yeah.
Realize that they may be in violation. Then they might want to respond versus I'll just keep ignoring, and then all of a sudden, so.
Yeah.
That was the reason I was asking.
I like the sidebar idea.
It could give a false impression. I think that the letters right now say maximum $1,000 per day. That's the water code section 13261 for failing to file a report. The board essentially takes the nature and extent of the violations into account when it assesses civil liability. So you're talking about threat to water quality, extent of noncompliance. So a discharger could see another penalty of $35,000, but you'd also have to think about, well, they're right next to the river. We first noticed them, as Brett detailed. Some of these folks have been on notice for years. Others have been on notice for months. Maybe that's an exaggeration. So,
my view is, I would not want to see precedential stuff sitting there because it could underwhelm somebody. Oh, it's only $25,000 or it's 80. I mean, so I would not go that route. And normally in enforcement matters, the potential is always what's hanging over someone's head. So if there's a way to make that clear, maybe it's the last chance phone call. But even in the letter, if it's, and I'm not trying to micromanage, but if we know that the date they should have was X, and that might be easy enough to sort of highlight. But
the way we're handling this right now is when we send out notices of violation, we include the press release for our most recent ACL settlements. So the NOV comes with the press release. It's right now it says it cites the Adwell case and the Heritage Ranch case, which the fine amounts were $51,000 and $54,000. So
I like the idea of the press releases. It's in the public eye anyway, so.
Maybe we could put like a watermark in there with like a skull and crossbones right behind it.
That's a good idea.
Only Carmen would suggest.
So the question about resources, and I don't know if this is a executive officer question or an Andrew question, or I mean it's presented like there's a tidal wave coming, and we need to do a few things to not get swarmed, but also the discussion we've had, and Carl mentioned that if we're not responsive to enforcement, if we're not fair across the board, if people don't think we're doing what we're supposed to and they can get away with it, that's problematic. So I'm not sure who to direct that question to, but I'll throw it out there. And that was John for the recorder.
Yeah, we are just on recording now, sorry. We've allocated, Sue's the program manager for this, we've allocated a certain amount of staff. We have a whole unit under Brett to compliance and enforcement. And, we're doing a lot of enforcement because of non-filers, and you heard him today say they're hoping to move into more compliance determination as well. But I think for the foreseeable future, because of all these new orders, most of it will be focusing on the enforcement. And if the board would direct us, then we could redirect our other staff over to this. Now that we've completed our orders, we still have documents to review. So I think at this time it might warrant a review to see if there's some more resources within the irrigated lands program that we could put towards enforcement for a short term. But we've got the groundwater assessment reports coming in. We've got staff working on nutrient management plan and those things. So our staff are just really stretched to the limits now as they are. Now we're doing the best we can to try and address some of these issues.
When we did it for the dairy order, it was not an ongoing thing. We held pre-hearings here in this room and in the hearing room in Fresno. I presume that it's conceivable that we could also hold one in Reading possibly. It may continue longer than the dairy program hearings did, but I foresee it not going on for a terribly long period of time, and once we get caught up, that the issue will be addressed, and we can handle it through more traditional means. Certainly, that's what's happened in the dairy order.
I'll also add one other option, and I think this is something that Chris Kerrigan brought up, might have been almost a year and a half ago when he spoke with you, but the executive officer or her delegee could actually conduct a hearing and issue administrative civil liability orders on the board's behalf using delegated authority, which would be even more streamlined. It would essentially look exactly like a hearing, but instead of the board sitting up there, it would just be the executive officer acting for the board. And I think that requires a lot of confidence in whoever you've delegated that authority to exercise judgment in line with the judgment that you would exercise. But that's another way of doing things in a more streamlined fashion to get these things done.
And I trust the executive officer, but I also feel like sometimes there's a crossover, even if it's not intended. Sometimes it feels like even the advisory team is a little bit more prosecutory than maybe the board is, and so I think that even though, like I said, I trust the executive officer and whoever her delegee might be, And I also find value in having it be board members.
Yeah, I don't think it's an issue of, I trust the executive officer, trust my life with her, but the issue is, I think it's important that board members be there. It sends a message.
I couldn't agree more.
Yeah, and I think it also appear more fair to the discharger when they show up and there's not two staff people and just them. So I think that that's good
The
too.
bullseye on my back is large enough.
I didn't mean to put another ring around that bullseye, just talking
No,
options.
I think the problem is then we're going to have dischargers showing up here claiming they didn't get a fair hearing, on and on and on and on, and then the board's going to be stuck with the decision of saying, well, we trust the executive officer, but we want to hear it. I think that's unfair to the executive officer. So,
Heard loud and clear.
and Chris made his suggestion in good faith, but he's a prosecutor too. So,
And I'll only add that I'll take your word that that the tidal wave will subside, and especially if there's more than one or two press releases to stick in the binder, folks should get the message. But
yeah, we have what? The numbers are entirely different. We have a little over 1,400 dairies. Am I correct? And we have how many tens of thousands of people? 85? Is that number right or wrong? Or
We got 53,000
53,000.
likely agricultural on this pyramid.
yeah.
Parcels.
So, about fourfold, maybe 40-fold, excuse me.
So maybe by the year 2016?
Well, I think by the time you have your grandchildren.
It's good. I'll have more time then.
Okay, any further discussion?
so did we?
Oh, right here is the, yeah.
So Sue and Brett, did we provide you with the guy, or are you looking for something else?
We still have a few more presentations.
No, I know, but
Okay.
we're taking it in blocks.
So what I'm hearing is that you do support hearing panels, you do support us sending out the pre-ACL letters,
Yep.
and then we'll be back in touch about the setup of the hearing panels.
Is there any board member who has an objection to that?
No.
Hearing none, there we go.
Yeah, and for the record, I'd be interested. I mean, if they were in Fresno, I mean, this is the kind of stuff I like to do.
Yeah,
But-
can you find a hearing room in Merced?
Does it have to be the same panel? Could you have two board members who are in the Fresno area and two that are up here in?
Yeah,
Absolutely.
We mixed it up
Absolutely.
last time. I served on both hearing panels, but there was different hearing panels.
Depends on the availability of the board members.
Yep. Any further discussion? Anything more, Sue?
Are we
No.
taking comments block by block? Or are we gonna be done with enforcement and then, and I only ask because by the time we get through these other, I don't know if an enforcement comment would be lost a little bit. It's more of a process question for you.
I think we should take any public comments now.
Mr. Chairman, for the record, Bruce Howard, South Valley Water Quality Coalition. Your administrative staff got so well recognized, they swooped the blue cards away. So, I did. Were you not paying
They got the
attention?
award because they took the blue card.
Something about make sure Bruce doesn't get a blue card. Anyway, you know what? I wanted to public.
It's a BYOB. Bring your own blue card.
I wanted to publicly acknowledge and thank and recognize in all the right words Brett and his staff. This is an art, it's a lot of art and some science. And we've worked closely over the years on outreach, and while the coalitions don't have a formal regulatory role in this, we sure do. We have an education and outreach role, and we take that very seriously because, as a couple of board members have commented, there's an equity issue. And I'm glad you're sensitive because it's the old 80-20 rule, right? You want to balance this out, so the 80% that are complying aren't going to suddenly have to pay for the 20%. Wish Clint was still here, because this is sort of like the marijuana issue. You got those who are legal and those who don't care about being legal. So I'm glad to hear the sensitivity of the board. And I want to thank Brett, because, you know, there's not a day that, not a week that goes by that I don't say, hey, how come this person got a letter but they're enrolled? Or, you know, or Wes Weemet, I hope you're listening, Wes, you know, says, hey, I just got somebody came down and filled out their ENOI, you know, can you help them get enrolled in the coalition? And we do it. So, and it benefits the whole. So, you know, I love that slide. I don't know which one it was, but if you look at that map, look at the Sac Valley Coalition, flip it over, and it pretty much takes up the other, geographically takes up the other coalitions. So while we're larger, we're benefit by having a lot of local folks at the Farm Bureau and the RCD who are talking to their growers on a regular basis. Thank you, Brett, for your work.
I'd like to thank you for your efforts.
Oh, no.
Not only here, but CV Salts.
Yep, thank you.
Thank you. Casey, and then Laurel.
It's Dr. Longley, Casey Kramer, Kings River Water Quality Coalition. For me, this is just two issues, and I think Brett highlighted it, the coalition issue. Really, if the priority issue, and that is non-filers and people who potentially will not submitting forms in the future. I think the non-filer issue is something that this board can tackle fairly easily, or more easily than the not filling out the forms. So, but the real issue that I'm going to struggle with is enforcement efforts on filling out forms with people who have joined the coalition. If they're getting violation letters before their neighbor who didn't join the coalition at all, that creates a huge dilemma for us. And so I can't tell you to not, you know, exercise your enforcement, but for the coalitions, that's an important thing, is to make sure that you get compliance with people enrolling before we start doing the completing of forms work. The second part on the forms, unfortunately, I think this is going to be a big issue. There's going to be people, we're not going to get 100% of members filling out every single one of the forms every single year. I know that's the goal, and that's what everybody wants to see done. If we start doing enforcement procedures with every single one of those things, it's going to tie up this board quite a bit. I don't want to tell you that you shouldn't go after people, but I think there's ways that we can work with the coalitions and work with the growers through letters and notifications, and people, if they're just continuing to not fill out forms, if like maybe 2 years in a row or something like that, then maybe that's where we start getting into it. But you don't have to make any of those decisions today. That to me, the form issue could be something a whole lot bigger and take up a whole lot more time. So I think there's maybe some other ways we can deal with that issue. But I just want to highlight that getting growers into the program should be the highest priority of the board right now. Thank you.
Thank you, Laurel. Then David Corey.
Thank you, Laurel Firestone, Community Water Center. Actually, more of my comments are for the other part of this agenda item, but on enforcement, you know, we agree. I think there needs to be enforcement starting with enrollment, and this seems like an efficient system to be able to do that. You know, and agree with the concerns around, you know, understanding that sometimes there's language barriers and things that you know, I think staff and the staff in particular is able to take into account in terms of how they're moving forward. But I think it's extremely important that we do enforcement, and starting with enrollment, but also not wait to have 100% enrollment before we start also moving towards enforcement of compliance with the program itself. And we do need to start moving towards that. And I think I understand Casey's concern, and we certainly shouldn't we shouldn't ignore enrollment. We need to start with that, but we can't just wait till 100% before we move on to really making sure that there's real compliance substantively with the real source control and pollution prevention, which is the purpose of this program to begin with. Yeah, I appreciate this. It seems like a thoughtful, good approach. Thank you.
And Laura, let me ask you this. Do you anticipate that if we did these panels that your organization would somehow feel, or the kinds of organizations that you represent would somehow feel like, hey, this is circumventing the public process or anything like that?
Certainly not at this point with the numbers and the purpose of enrollment. It seems like this is something that, you need to come up with efficient ways of being able to move through. And we would rather make sure that you're able to get through the effective enforcement actions.
And I would note that Bagley Keene does have notice requirements for the hearing panel. So we would have to notice them in much the same way that we notice a regular hearing. Probably look a little more like a workshop, but the board's going to be there. It's going to be conducting a hearing. We have to put it out there for folks to know about it.
And testimony by interested parties. Is it going to be that whole thing?
It's the full shebang. It's just about everything except when there's no gavel that drops. And so essentially, at the end of the hearing, you say, we think this is a good number. We're going to write up a recommendation for the full board and see in a couple months where we're going to present this recommendation to the board.
Thank you. I'd like to thank you, Laura. I'd like to move on. We've got a long ways to go. David, did you want to talk? This. Okay.
I actually agree with both of them. So.
Good.
No, not very.
We can call on you later, David.
Okay. So are we going to go with who's present? Glenn now?
I thought we were going to go with mine.
Okay, good.
So, again, Sue McConnell. So this is a continuation of the information item from the June board meeting on disadvantaged communities, or DACs. And today, I want to revisit the recommended tools for identifying the disadvantaged communities, discuss the outcome of a stakeholder meeting held on July 14th with coalition and environmental justice representatives and other interested stakeholders who are disadvantaged communities. That was the major agenda item. I will give an overview of the Irrigate Lands groundwater protection strategy and then explain why we should prioritize these DAC locations and what that prioritization means. So as discussed in June, the Department of Water Resources, or DWR, has a web-based DAC mapping tool, which is used by the integrated regional water management efforts and the coalitions, and allows DACs to be mapped as census tracts, census block groups, or census places. So for the Irrigate Lands program, staff recommends using the DWR tool with census places as a starting point for identifying DACs, as shown by this figure. It's important to note that census places includes both incorporated and unincorporated places tracked by the census, and because disadvantaged unincorporated communities are a special concern with regard to safe drinking water, studies have been conducted to identify those not tracked by the census. So one such study was conducted by PolicyLink, and the study found that disadvantaged unincorporated communities not tracked by the census have more low-income households. The study identified disadvantaged unincorporated communities in the San Joaquin Valley using census data from 2000, and currently this tool covers just over half of our region. This figure shows the PolicyLink disadvantaged unincorporated communities in pink, overlying the DWR DAC places in blue. So another study was conducted by the Tulare County to assess drinking and wastewater needs of disadvantaged communities in the Tulare Lake Basin, with a focus on rural and unincorporated communities. The study covers Fresno, King, Tulare, and Kern counties, and incorporated information from PolicyLink, the Department of Public Health, and the 4 counties, including specific information regarding drinking water supply and quality. This figure shows the Tulare Lake Basin Water Study DACs in lime green, overlying the policy link communities in pink and the DWR DAC places in blue. So as a starting point for identifying disadvantaged communities, staff recommends using a combination of these tools, the DWR mapping tool, in conjunction with site-specific studies like Policy Link and the Tulare Lake Basin Water Study when they're available. During the July 14th stakeholder meeting, we discussed staff's recommendation to use the combination of the tools as a starting point. And we say starting point because there are ongoing efforts to collect disadvantaged community information, which will be included in the irrigated lands process at regular intervals. So during the stakeholder meeting, there also was a proposal to just use the Tulare Lake Basin Water Study as a tool to identify disadvantaged communities. And while that study contains really good information on disadvantaged communities reliant on groundwater and would be useful for prioritization refinement efforts, staff doesn't support it just using it solely because it doesn't address the incorporated areas with drinking water needs. So also at the stakeholder meeting, we discussed the implication of disadvantaged community identification and prioritization and its relationship to phase implementation, which I will cover in the upcoming slides. So to provide context for the prioritization discussion, here's a brief overview of the irrigated lands groundwater assessment and protection strategy. As a part of the strategy, the irrigated lands regulatory the general orders require the following 4 elements: groundwater quality assessment reports, which provide the 4 elements of the groundwater quality assessment report, the management practice evaluation program, groundwater quality trend monitoring, and then the groundwater quality management plan. The groundwater quality assessment report provide the foundational information for the other 3 elements and requires identification of high vulnerability areas. The management practices evaluation program determine effects agricultural practices might have on groundwater under different conditions. The trend monitoring is to determine current and long-term groundwater quality conditions so that we can evaluate regional effects of agricultural practices. And then finally, the groundwater management plans describe how the coalitions will help their members address identified water quality problems. The groundwater quality assessment reports, like I said earlier, include a determination of high vulnerability areas where irrigated lands may degrade groundwater quality. Glenn will discuss the vulnerability area identification in more detail later. What I will cover are factors for prioritizing work within the high vulnerability areas. If a coalition is able to address their entire high vulnerability area at once, there's no need to prioritize. But if prioritization is needed, the general order lists factors to be considered, including identify exceedances of water quality objectives, either caused or contributed to by irrigated agriculture, the proximity to recharge areas for groundwater, municipal or domestic supplies, existing agricultural practices that cause or contribute to groundwater problems, and then the largest acreage commodity types and their irrigation and fertilization practices. So the nexus to the disadvantaged communities is that second item. As we look at proximity to recharge areas, it makes sense to look at the most vulnerable areas that are supplying municipal and domestic supply. So why should disadvantaged communities be prioritized in the irrigated lands regulatory program? In 2012, California enacted the Human Right to Water Law, which states that all Californians have the right to safe, clean, and affordable water. In the irrigated lands program, staff considers this law by prioritizing groundwater management practices near disadvantaged communities reliant on groundwater. And that's because small, rural, disadvantaged communities are disproportionately impacted by groundwater contamination. These communities are more vulnerable because they have limited infrastructure. In fact, over a quarter of the Tulare Lake Basin disadvantaged communities have drinking water wells or have drinking water supplied by a single well, putting these communities at greater risk if the well were to fail, since there's no opportunity for blending when the well becomes contaminated. To add to the concern, disadvantaged communities tend to have shallower wells that are more easily contaminated. Disadvantaged communities also have limited resources for water treatment or for installing deeper wells. And even when grants are available, they have inadequate technical capacity in that they might not have the resources to obtain the funding or implement the projects that they would need to get done to protect their drinking water. And for all these reasons, it's important to prioritize disadvantaged communities in the Irrigated Lands Program. I'm going to get to the question, your question from the last meeting, which is, what does prioritization mean? For the Irrigated Lands Program, prioritization means the recharge areas of disadvantaged communities reliant on groundwater are addressed first when coalitions are phasing in groundwater implementation activities. So this includes determining the location and the timing of the implementation activities, which, granted, makes more sense sometimes than others. So if a coalition is targeting a key crop within their area and they're outreaching to all of the growers of those crops in a 3 to 6 month period, we're not asking for prioritization. However, if they're reaching out to growers with abandoned wells, let's say, and they can only get to 15% of their growers every year, then we would ask that they focus their efforts near recharge areas of disadvantaged communities that are reliant on groundwater first. Also, there should be consideration of disadvantaged communities in the development of the trend monitoring program. So finally, staff recommends prioritization of disadvantaged communities reliant on groundwater in our strategy to protect groundwater in the Irrigated Lands Program. And as a starting point for identifying disadvantaged communities, staff recommends using the combination of the DWR mapping tool in conjunction with available studies on disadvantaged unincorporated communities and drinking water. This concludes my presentation, and I'd be happy to answer any questions.
Thank you very much. Other board members may want to weigh in on this, but I think that you've done a good job of describing what prioritization is. You're certainly, the very small communities are the ones that have the hardest time, as I think you pointed out. They don't even, and the other issue they have is they don't have the resources for O&M for their systems. And I, unfortunately, because it just came out, Senator Feinstein has put together some legislation, and I know they were talking to me about it. They wanted to focus on the smaller communities, very small communities, and it's my understanding, I haven't read the bill, it's my understanding that they were going to put language in there talking about a distributed treatment in an effort to try to build the scale that's needed to be able to develop the resources that you point out these communities don't have. This is a very severe problem. I know the CSU has also put together an effort that the California State University system has also put together an effort where they're going to have a center, or they have a center now, focusing on these communities. They have the funding, but they haven't hired the staff. They're going to have some 10 permanent staff focused on these small communities to try to provide those kinds of resources. That's only is going to address the tip of the iceberg. This problem is very significant, and we still don't have the kinds of resources, despite the Feinstein bill, if it does become law. And despite the CSU effort, takes a huge amount of resources to be able to address it. Discussion by any other board members?
I appreciate you coming back to the board with this, Sue, and I think you did a great job. I really like the fact that you are going to use the Tulare Basin water study for disadvantaged communities, because that's the basis of a lot of the information you're going to be needing. All those communities were studied and what their needs were, technical support, all of those issues. They're there, and it's a good starting point, and you really utilize it, and hopefully it will begin to make a difference as we try to address the issues of water quality in the disadvantaged communities. Thank you.
John?
So I think some of these questions were mine from last time. I think this was a very thoughtful response, and I appreciate the secondary response you gave at the end, where there's a 3-month blast of things, and that not everything is prioritized all the time. But the question I had was, how is this? What is this? Is it a memo? Is it policy? How is this going to get rolled out? Just so Bruce and Casey sort of understand what it is, and or is it for them? Is it for us? Is it, you know, what does it look like at the end?
Right. So maybe I should have been more clear. You know, this is an existing part of our program, the Irrigated Lands program. So within the groundwater quality assessment report, there is there is an opportunity to prioritize work within the high vulnerability area. And so when you're doing that, you know, there are factors that the coalitions need to consider, and one of them is the proximity to recharge areas. And so, you know, what we're saying is that's an important factor to prioritize, especially in the vulnerable communities, you know, vulnerable areas. And so it is already included in our program. We're not inventing anything new. We're just highlighting that within the groundwater protection strategy that is in the Irrigated Lands program, you know, there is language for protecting areas that recharge areas, and we're saying pay special attention to disadvantaged communities because they're particularly vulnerable.
If I could weigh in here, Sue's correct, but the other issue is we are continuing to respond to documents submitted to us, and some of these things come, it's important that we be consistent in that some of the coalitions hear that the board has given us a general nod of approval on certain approaches, and some of these things are more sensitive to some of the coalitions than others. And so this item here and the next one you'll be hearing from Glenn and Clay on the high vulnerability areas, I felt it was important that we get the board to give us either a general nod, because when we send the letters out with our comments to the coalitions, they know that this has come with some general a nod of approval from the board members at an information item in the public hearing.
And that's helpful, that it's basically sort of out there for staff to address as needed. It's not some document that we're preparing that's fine. Thank you.
Because the order doesn't really say, you know, prioritize disadvantaged communities. The order says to prioritize proximity to recharge areas, and staff is taking the position that recharge areas for disadvantaged communities, because they're particularly vulnerable, need to be prioritized.
Okay.
Okay.
And so with that, is there anyone in the audience, interested party? Laurel, do you want to weigh in on this?
Not unless somebody objects to it.
Okay. That was a good enough answer. I don't know. Bruce is ornery enough. He just might come up and say he objects to it, even though he doesn't, just so to get you up.
It's 5 o'clock on Friday, so I'm just going to agree with everything Sue says now. So, obviously, I think the Tulare Lake Disadvantaged Community Study is the best study that's out there that identifies the communities that we're trying to correct the situations. And so, my objection to this is the layering. I think there's a study out there that's the best, and we want to use that study. I don't see a whole lot of differences between the other tools, but it's how this is going to be used in the groundwater assessment reports and high vulnerability areas, but I'm not against identification of it.
Thank you, Casey.
Dr. Long, if I could say, I understand what he's saying, and I agree that when it comes to identifying the disadvantaged communities is one thing. In their prioritization schemes, that's where they could use these more refined studies to help justify why they're going to do something sooner than others.
Thank you. Yes, Bruce?
Could I have a minute and a half so I don't take 3 minutes?
30 seconds.
Okay. First, let me start with an apology to the board. Bruce Hattersell, Sac Valley Water Quality Coalition. So when Sue came and gave this presentation last time, I stood up here and I go, yeah, Yountville, disadvantaged community. I had my iPad this way, not this way, so I didn't see what she was looking at, the place area. I saw this bigger blob, so Pamela and I had a little exchange about Yountville. I need to learn to put my iPad like that so I see the whole page. So let me start with that.
Bruce, I've had those conversations with Pamela too.
Okay, good. And I think this is important. A couple of things that were triggers for me was this is a starting point. In my looking at our GAR and drinking water in communities that depend on groundwater, there are other things I think that factor in, and I just want to make sure that the record reflects that I think that things like the AB 2222 study, which show funding that are going to communities like Live Oak. We have an arsenic exceedance in the lower Snake River. And so, there's 4 groundwater wells that Live Oak is taking care of, right? So you need to, in addition to, you can't look at this in absentia, just like you can't look at the GAR in determining high vulnerability. You really do have to take a comprehensive look at the good work that CV Salts is doing and the modeling and looking at the assimilative capacity, looking at the management practices at the surface, and then you have a comprehensive understanding of groundwater quality, the impacts and the trends to groundwater quality, and the significance of, because maps are so powerful. You put a line on a map, a habitat conservation map, it's going to be a long line here. So it's important that there's that contextual setting. Not all communities have some of the criteria that Sue mentioned: limited infrastructure, limited resources, inadequate technical capacity. There are communities that are out there going for state funding to get their wells replaced, to get all that. So that's how I just wanted to, again, the word is art, wanted to make sure that anything that's done here for documentation, there's a comprehensive look at groundwater quality and the trends in groundwater quality. Thanks.
Thank you, Bruce. Laurel?
Laurel Firestone Community Water Center. I actually think we all agree, and that it seems like pretty clear that this is basically saying that you want to use the best available data and make sure that you're considering disadvantaged communities within prioritization schemes, not as the only factor, but within the full picture. And I do think this is a really good example of implementing the human right to water policy and making sure that as we're implementing programs through state agencies, that we're looking at how we can ensure that communities that we're achieving the ultimate goal of communities having access to safe, clean, affordable drinking water. And this in the source protection context is really important. So I appreciate this. I think it's a really good example of that implementation. I think I said this before, our concern is actually that the data identified, especially in places like the Sac Valley, isn't as good as it should be, and that our hope is that the state board releases public water system locations soon and makes data more available that's more useful for coalitions to make their programs even better and more tailored. And we understand that they're working with the data that exists, and that's what they have to work with, and they need to move forward. So thanks.
Thank you very much. So I think we're ready for the last presentation. You didn't think we were going to get to you, did you?
No, I was starting to worry there. Let me just close this up for now and then. this about the right level. Good afternoon, Chair Longley and members of the board. My name is Glenn Meeks. I'm a senior engineering geologist in the Irrigated Lands Program and also CV salts. My presentation today will initially discuss a little background on the Groundwater Quality Assessment Report, known as the GAR, as well as some order definitions. I will then discuss some common issues relating to the groundwater high vulnerability determinations that staff have encountered, as well as the approaches taken to address those issues. And finally, I will present staff's recommendation for moving forward. As Sue indicated, the Groundwater Quality Assessment Report, or the GAR, provides the technical foundation for implementation of the order's groundwater elements. Objectives of the GAR are to assess all currently available data and information to determine high and low vulnerability areas where discharges from irrigated lands may result in groundwater quality degradation, and also, as Sue presented earlier, to establish a prioritization of future monitoring efforts, special groundwater studies, and the development and implementation of groundwater quality management plans within the designated HVAs. High vulnerability area, or HVA designation, is made in the GAR. The orders provide that groundwater areas can be assigned a high vulnerability designation based generally on 3 criteria: known groundwater impacts that exist for which irrigated ag is a source or potential contributor, geologic and other physical conditions that make groundwater more vulnerable or susceptible to impacts from irrigated ag operations, which I will refer to later as intrinsic susceptibility criteria, or areas where groundwater quality management plans are required. Groundwater quality management plans are required for areas where there's confirmed exceedance, areas where there's a trend in groundwater degradation caused or contributed to by irrigated ag, areas where the basin plan requires one, and all HVAs as determined in the GAR process. By now, most of the coalition groups have prepared and submitted their GARs, and reviews have been underway. Several common issues have been identified during these initial reviews, as well as some of the pre-GAR meetings, most associated with designation of high vulnerability areas, and one related to prioritization of future provisional work. These common issues include data quality adequacy issues, HVA assessments that only evaluated coalition member areas or excluded urban areas from the HVAs, assessments that only included areas that had available groundwater quality data or that used non-representative groundwater quality data to eliminate an area from an HVA, assessments that were based on only one single criteria, and finally, GARs that didn't prioritize their HVAs for future work. Now, the majority of these issues have already been discussed with the coalitions in GAR follow-up meetings, and a lot of the GARs have been revised to reflect the current approaches being utilized by staff. So I will now discuss each issue in a little more detail, and in your agenda package, there is a list that kind of summarizes each issue as well as our current approach, so you can kind of follow along. Because as Sue indicated, we're kind of looking for feedback from you guys. One of the first issues encountered during GAR reviews is the use of data that are not the most up-to-date, or that the amount of the data that was utilized was insufficient to properly assess vulnerability based on both past and present agricultural land use. As indicated earlier, order requirements specify that GAR should provide an assessment of all available, applicable, and relevant data and information to determine high vulnerability areas where discharges from irrigated lands may result in groundwater quality degradation. To accomplish this objective, the assessed data must include detailed land use data with emphasis on land uses associated with irrigated ag operations, soil survey information, especially areas of high salinity, alkalinity, or acidity, and of course, groundwater data, such as depth to groundwater, groundwater quality data, and information on existing groundwater monitoring efforts. Current approach to this data issue has been to request the most recent land use and cropping maps be provided in the GAR, along with historical land use data. The evaluation of both current and historical crop data should be stressed, as historical crop data may be the best indicator of the types of constituents of concern that may be present in groundwater, and may also indicate if and when crop changes have occurred in the past. Staff also encouraged the use of the most recent soil survey information, such as the Natural Resource Conservation Service's Soil Survey Geographic Database. With respect to the review of groundwater quality data, current approach has been all available and relevant data and information should be reviewed for all constituents of concern. This includes the most recent data set, as well as any information on applied materials such as fertilizers or pesticides that could potentially impact groundwater beneficial uses. Where multiple years of groundwater data are available, analyses should include time series concentration analysis to identify any trends, increasing or decreasing, analysis using the maximum constituent concentrations detected in a well, as well as concentration depth analysis if sample depth is known. The data should also be reviewed in context to the area's hydrogeology, basically to identify if there's multiple aquifer zones present, such as unconfined, semi-confined, or confined, and also to identify from which zone the samples were collected from. The second issue encountered during the reviews is that some of the HVA assessments, they only evaluated areas where coalition members were located, or the assessment excluded urban areas from the HVAs. As indicated earlier, the GAR required data components need to be evaluated to determine where impacts already exist or areas that are based on intrinsic susceptibility. It is the second criteria that influences our approach to this issue. Current approach is that HVA determination assessment should include all areas within coalition's boundaries with where either irrigated ag operations currently exist or where new ag operations could be placed. Staff's rationale is that new farming operations start up every year in areas that were previously non-farmed or non-irrigated. This is especially true in the foothills where new almond orchards and grape vineyards are going in every year in places that were previously not farmed. By including these non-ag areas in the initial HVA evaluations, it allows the coalition to inform any new members that move into these areas whether their operation is located within an HVA or not, and if so, what management practices will need to be utilized without having to wait until the next GAR revision in 5 years to evaluate the new area. The GARs that excluded HVAs or urban areas from their HVAs, hold on a second here. The GARs that excluded areas from their urban areas from their HVAs indicated in the report that since the area was urban, there was not any irrigated ag operations present. However, we don't agree with this assumption, as staff are aware of many small growers known to operate within city limits. Strawberry growers are a prime example.
Glenn, going back, the first bullet on the handout that you have.
Yeah.
The only kind of flag that comes up for me on that, it says if no coalition members are present in parts of the HVAs, no additional work by the coalition is required. But we might have some islands that are currently unfarmed or apparently dry farming, but they're part of a larger area, and it's conceivable that we would need to know what's going on within those areas to be able to fully understand what's going on in the coalition.
Well, in the order, we've got we can actually ask for additional special studies, so that might come under that jurisdiction where we can just say, this is kind of a special case. I mean, basically, if a lot of this came up in areas where the new, like almond orchards or grape vineyards go in, a lot of those areas, maybe citrus areas, they're really sandy. There might not be farm members there right now, but everything in the coalition area should be evaluated so that we're not waiting at some point later if somebody moves into them.
We have certain areas too that have been farmed that are no longer being farmed, and anyway, okay, so you have that covered. I'm satisfied. Thank you.
Okay. Yeah, and that goes into my second. If no coalition members are present, then there's really no additional work until somebody moves into that area. A third issue encountered during the reviews is that the GARs only evaluated that areas that had groundwater quality data, specifically nitrate data, but didn't consider pertinent geologic or hydrogeologic information within those areas that contained little to no groundwater quality data. Again, it's the susceptibility criteria that covers these areas where either groundwater quality data may not be available, but physical properties such as soil texture, depth to groundwater, etc., are available and indicate that the groundwater is potentially vulnerable to impacts, and therefore the area should be designated an HVA. Current approach to this issue by staff is that all areas that have physical properties or conditions that make groundwater vulnerable to impacts from irrigated ag operations should be included in the HVAs regardless of whether groundwater quality data is available for the area. Additionally, areas that don't have groundwater quality data but have similar physical properties to the surrounding areas that basically been indicated to be high vulnerability area should be included in the HVAs because of the same physical properties, just not because there's not a need for there's no groundwater data available. Moreover, the groundwater quality data used to assess the area for vulnerability needs to be representative of groundwater conditions. These two approaches avoid the checkerboard pattern that you see on the slide, where either an area that didn't have groundwater data available to it, for that one section, is surrounded by HVAs that are defined based on groundwater data, and it wasn't included in the HVA, it needs to be included, or that area had just deep groundwater data, which isn't representative of shallow groundwater, and the surrounding HVAs were based on shallow conditions. In that case, if the physical properties of that area that just has the deep groundwater data available to it, it should also be included if the physical properties are the same as the surrounding HVAs. Because just because we don't have the data doesn't mean that it's still not an HVA. The fourth issue encountered by staff is that some HVA assessments only used one criteria, such as nitrate MCL exceedances, to identify areas as HVAs without looking at other constituents of concern, intrinsic susceptibility, or at increasing concentration trends that may become an exceedance in the future. The Orders Monitoring and Reporting Program, the MRPs, require the vulnerability designations be made by the coalition using a combination of physical properties and management practices. However, until management practices are proven to be protective of groundwater through the MPEP, or the Management Practice Evaluation Program, they should not be utilized to mitigate physical properties that make groundwater in an area more susceptible to impacts. Additionally, some management practices may actually contribute to groundwater problems, such as the flushing of salts from the root zone. An additional related criteria that can designate an area an HVA are areas where the executive officer has determined irrigated ag may be causing or contributing to a trend in degradation that may threaten beneficial uses. It is this trend in degradation, that criteria, that influenced the first part of our approach to this issue. First, HVA should include all areas that have nitrate or pesticide exceedances, but should also include any areas that have nitrate or pesticide concentrations at or above 50% of the associated maximum contaminant level, or MCL, and they exhibit a statistically valid increasing concentration trend that may impact groundwater beneficial uses. Now, we do understand that sometimes there isn't enough data to determine, a valid trend, but when there is a valid increasing trend for an area, and they have an exceedance over half the MCL or equal to, those areas should also be included in the HVA. Secondly, as per the order, HVA assessment should use a number of different parameters or criteria to determine HVAs. Also, staff feels that HVA should be determined with more emphasis on physical properties such as soil type, depth to groundwater, etc., and shouldn't be determined using only one criteria or analysis methodology, especially if that methodology overrides intrinsic susceptibility due to a heavier weighting of a management practice, as is the case with the Nitrate Hazard Index tool, the NHI tool, which puts heavier weighting on certain irrigation practices that can override intrinsic susceptibility that would otherwise designate an area in HVA. The NHI tools can still be utilized for prioritization of future work within the HVAs, but shouldn't be used for HVA determinations until the management practices have been proven to be protective of groundwater through the MPEP. Additionally, crop management practices can and do change relatively quickly in the ag community, whereas physical properties remain fairly constant over time. The final issue that I'm going to talk about is related to prioritization of HVAs for future provisional work, in that some of the GARs that have been reviewed failed to prioritize the HVAs for this future work. Per the order, one of the required tasks of the GAR includes prioritization of the HVAs for implementation of trend monitoring, groundwater studies, and for establishment and implementation of the groundwater quality management plans. Current approach to this issue is that prioritization of HVAs is required under the order, and therefore it needs to be included in the GAR. As you can see, our current approaches to these common issues have been based predominantly on order definitions and/or requirements. Staff's recommendation is that the current approaches continue to be utilized unless new data associated with a specific issue warrants a change in the approach. Use of the recommended approaches will allow staff to review submitted GARs in a timely manner and consistent manner, and will hopefully minimize any confusion as to the purpose and objectives of the GAR and its related components. Additionally, the GARs are to be revised and reevaluated every 5 years, at which time additional data such as MPEP results or trend monitoring results should become available, and at that time we can readdress these issues and make any changes to our approaches if necessary, such as allowing the use of management practices that have been proven to be protective to be utilized to help mitigate intrinsically susceptible areas. This ends my presentation, and now we'd appreciate any kind of feedback that we can get from you guys on our approaches.
Comments, questions?
Can we hear from stakeholders first?
Well, I wanted to know if any board members at this point had a question. Seeing none, we'll do as we've done in the past also and ask for stakeholder input.
All right, thank you.
Dr. Longley, members of the board, Casey Kramer, Kings River Water Quality Coalition. There's probably a lot of issues, more than what we can address here today. I wouldn't be doing my job if I didn't express to you the major concerns that my board had with the process that we went through, the expense that we undertook, and basically the results and basically where we're at today. They probably wish we would have never spent the money and we would have just let board, decide what the high and low vulnerability areas. There's a lot of things that were presented here today, and I think it's one side, and there's some things I don't think were actually accurate. One of the slides was slide 9 was showing our coalition area, and it basically said that it didn't identify with drinking water or with actual groundwater results, and that's not true. Where there was water quality data, that was considered. There's also a lot of areas with very good water quality, and then so anyway, we could debate a lot of things, but I'll just say that we went through this in a good faith effort. We worked with staff in a good faith effort to try to come to some sort of conclusion to a lot of things. I think there was just a differing of how the order read. The order told us the management practices. It said identify high vulnerability areas considering management practices. And then I think what you heard here recently is that we shouldn't be considering management practices until MPEP. So I think there's a lot of confusion with how the order was written. And then that we went forward and conducted studies and spent a lot of money on it. And then here we are 2 years later or whatever, and we're still debating this. I'm very concerned with going back to my board here in a couple weeks and telling them we're gonna have to spend more money on GAR because they've kind of had enough and just, okay, let's just move forward. So there's more in this presentation that I think we can address today. We're concerned, but we want to work with staff and work with the board to a reasonable solution for everybody involved.
I'd like to hear a response to Casey's concerns from staff.
Hi, this is Clay Rogers, Assistant Executive Officer.
I mean, certainly we did consider, and the GAR did consider water quality data. That was very clear. I think also we did consider management practices. We allowed implementation of the nitrogen hazard index in a number of areas in the southern San Joaquin. I can tell you the primary issue we had with the original GAR that was submitted by the Kings River Water Quality Coalition was that it included it did not include large areas on the east side of the San Joaquin Valley where we knew there were communities that had significant problems with nitrates above the MCL. And many of those areas that are actually undergoing replacement water supplies because their groundwater does not meet the water quality objectives, were not included in the GAR. And so we ended up, with a high vulnerability area that looked a lot different than what was originally proposed. But I do believe, the coalition has been seriously looking at this. I do believe we've been working together. I do believe that we have used some of the management practice information, certainly within incorporation of the nitrogen hazard index or modeling such as the Kings River Group did. But when it doesn't correlate with the data we have, when their evaluation says that there are not problems where we have very significant problems, it is problematic for us to accept that on its own.
So Dr. Longley, if I can add to that, some of them, use of those other tools was appropriate where we had absolutely nothing. But they were giving some pretty high factors to best management practices that we don't have any evidence that there actually are protective of groundwater quality. So it put us in, it's like, did their weighting factor, was it correct or not correct? We didn't know, and it's really not where we have other information to counter that. We couldn't put a lot of weight to it, and I think that's where a lot of our discrepancies came. They wanted to put a lot more weight to those practices that haven't been proven to be effective yet. And so that was a dilemma for the board, and this nitrogen hazardous index is a tool, but even those who promote the use of it won't tell you that it's an indicator that water quality isn't impacted. So until we have more information, it's a tool that could be considered, but it's a difficult tool to use to say something has high vulnerability or not at this time.
Understand, I'm familiar with NHI and its limitations. Thank you. Do any of interested parties wish to comment at this point?
Yeah, Laurel Firestone Community Water Center. We submitted comments because we were really concerned about the first draft of GARs that went out that we thought were really inadequate and didn't adequately capture high vulnerability areas and like Clay said, areas where we knew there were major problems. And so we really appreciate staff's work with getting the improvements needed to have adequate high vulnerability areas identified, understand the frustration with having to spend a lot of money on consultants and not having that study be adequate by the coalitions. But I think that in this case, it was really needed to have the board step in and require the improvements. And I think a concern from ours from the beginning of this development of these orders was we didn't want to have areas be not included as high vulnerability areas where we didn't have, for example, private well testing, where we knew that there were high vulnerability areas. They likely had nitrate and all the other characterizations of the hydrology and land uses indicated that they likely would, but because we didn't have data that they would be excluded. And I think that the recommendations and what has been done is consistent with addressing that appropriately. So appreciate it.
Thank you.
Bruce Hadelschelt, Sacramento Valley Water Quality Coalition. I think Casey said it well. There's a lot here to digest, a lot here to understand what it all means. Map the entire coalition area. I think we did that in the Sacramento Valley. Look at areas that potentially become agriculture in El Dorado County where there's no groundwater quality basin. I think I did that. But if somebody goes out and decides they want to do an agricultural operation, just like somebody who goes out and decides they want to put a residential community in place, they need to do their due diligence. As the board astutely was sensitive to earlier, the coalition has this straddling role where we're not the regulator. I'm not going out and telling somebody who wants to put a vineyard in or an orchard in, you're in a high vulnerability area. That's their due diligence. My job is to educate them on what the requirements of the order are and to do outreach. But I'm not going to go tell somebody and take on the liability of saying, of that. There's a lot to digest here. Half of the MCL, well, is it trending? Is it, you know, as I mentioned, we looked at all, I mean, our GAR has monitoring data back to the, I think, 1944. Also has the most recent monitoring data. We have all the wells. We followed the GAR requirements, spent $400,000 on that. Spent, by the way, just to get the numbers on the table, to set up a system to implement the farm evaluation collection, to have the database system, to educate growers. And we're submitting the report today on the summary. We probably spent $750,000 on that reporting requirement. So these are, you know, there's a lot of headlines about what growers make and what they don't make. You know, we've got a lot of irrigated pasture in the Sierra Valley. As I said earlier, you might have groundwater quality monitoring, but you really need to look at the trend line to make a comprehensive assessment. And you do, you know, you take in all the information that's out there. So there's a lot to digest. I appreciate what staff is interpreting the order to say, but, oh shoot, my dinner bell, okay. Anyway, it does feel like the playing field is shifting through the interpretation. And so I think there'll be a robust conversation that goes on. Thank you.
Thank you, Bruce. You want a minute? You want just a little bit? 15 seconds.
Casey Creamer again. I just want to leave you with this note. We looked at all available data, water quality data that we had available, publicly available. And so I don't want you to think that there was available water quality exceedances that we disregarded, because we didn't. And we'll continue, if there's more, we'll work in good faith with staff in order to do that. So we'll continue to work with them on that. But it was never anybody's intent to take you know, known water quality data and leave them out of the report.
Yes, David.
It's late in the day, so I'll
You let the mic.
Come over to the mic.
Got to get recorded.
David Corey with the West Side Coalition. It's late in the day, so I'll forego my 3 minutes this time for 5 minutes in a future meeting.
Was that all? Any discussion by the board? Any comments?
Yeah, I don't know if Denise, do you want to say anything? No. Okay, so as Casey and Bruce mentioned, there's a lot here. Disregarding the fact that it's 5:30, there's a lot sort of presented to the board under the guise of an information item, yet it was obviously more of a discussion item. I just want to throw that out, that it's hard to, and I went back and looked at the buff sheet, and it says the recommendations are coming at us, rather than what I think I heard was, we really wanted some guidance, and I don't know if there's a distinction between a voting item, an informational item, and a discussion item, but you know, I don't multitask that well that I could read this, digest it while the visual was going on and Glenn was talking, and so I don't really have anything. I don't have any feedback because I really couldn't process everything at the speed at which it was coming, and I don't like to sort of say that way, but I couldn't, and maybe I just don't know the details well enough that it bounces off my head in a way that I can think about it, but I'm just throwing that out there, that's one of the reasons I just don't have a lot to say, and I don't know if that means you didn't get the guidance you needed, but
It means it's late in the day.
I will say.
Sue, just a second. Sue and Clay and Pamela, do you think that you have enough feedback from this board today? We had 3 items, and my guess would be that on the first 2 you might say yes, but the last one.
No. I'll answer for you. So, Dr. Longley, this was after we decided to put this on the calendar. The other 2 items were added as a result of last meeting. We had hoped to have just 1 item on the HVA issue and discussion with the board. It was when we met with the Kern Coalition that you, I, and Clay decided it was probably best we bring this to the board to discuss, because we were having so many comment letters and discussions with the coalitions that the board would have a chance to weigh in and agree or not agree with how staff was defining the board order. And some of the coalitions have responded, but we had made that commitment we would do it. So that's why we're here.
Right.
And so, but unfortunately, we had those holdovers of requests from the board from the last meeting. So we tried to squeeze them into 3. It's, decision fatigue at the end of a long day. It was probably not a good time to do it.
Well, with that said, I think we can focus on the last one. And I know I've talked to Clay about this and some of the problems that he's running into, and it's obvious that we have to keep up a dialogue. It's obvious to me, at least, that we have to keep up a dialogue with the coalitions. Misinterpretation, or by any party, including us, of the order, of course, is something that's going to take a lot of work to get by. But at the end of the day, on some of the stuff I saw was going on, it didn't make any sense to me. And I think, for the record, I will say I agree with the approach that you folks are taking, and that's maybe because I've been a little closer to it and been briefed on what's going on. But I think that what I saw today, what you presented, is the direction that we have to keep going. With that said, we need to keep working with the coalitions. As was pointed out by Casey, it costs them a lot of money. Their board is unhappy with where they're going. Well, I don't know. I can't comment on that, but we as I've talked about earlier in the day on other subjects, we need data, and we can't regulate without data, and this program has to go. And it can only go with data, and I'm sorry, but that's the way it is. And I don't know if any board member wants to comment on my comments, or
I just want to say, there was a brief discussion about ground truthing, basically. There were areas that people knew are impacted. And I think in this program where we're trying to model and get all the science and right and get that figured out, that's important. But at the same time, if you get some of the key people in a room, you're going to figure these high vulnerabilities out based on all their expertise pretty quick. And that ground truthing is going to be really important in terms of determining what the model is. And as we move forward, even there's probably plenty of information out there from the board's perspective, and not the coalition's, the board's perspective, to say we know this information that these key communities or these key locations are high vulnerability areas. Let's start focusing on those maybe so we can get action moving forward while we're doing the rest of this. So I think maybe a two-prong approach that both looks at the long term, but also is there relief we can give to these communities in the short term? And I know actually that's being done in some forms with providing alternative water for these that we have to, but in terms of how we manage these lands in the short term in these areas that we know about, I think putting that forth too, and then I think everybody's on board for that, and then let's get the science that we really need to support the long-term efforts. That's my.
I just have one comment for Casey and your concerns. I think that the reason your being here is and the coalition and the work that you're doing is commendable, and I encourage you to keep at it and keep working with your members. And I think your being here at this late hour shows your commitment, and this collaborative effort can only improve. And the bottom line for all of us is that state law, the human rights to water, and I think that's what we're focusing on, and that's why those high vulnerability areas that we're focusing on right now are really important, because we don't want people to be left out of having good drinking water. So thank you, staff, for the excellent presentation, and we'll look forward to the next part of this process.
Very good. Any further discussion? I expect that this is going to be brought back to us as you continue to process the GARs. And I can't say we look forward to it coming back, but I think it's something we're going to have to continue this discussion.
Well, Dr. Longley, in fairness to designating something as a high vulnerability area triggers more requirements, higher costs. And of course, there's always the fear of what someone will demand that we do because someone's now located in a high vulnerability. And of course, always the growers are concerned with potential lawsuits, that it's always brought up in all the conversations. So, you know, I understand their concern and worries. So we're not trying to make it so it's a broad brush type of an approach, but we are trying through what Glenn's presented today. I should say, the 50% of the MCL wasn't really discussed with us. It was more of a trending up where we thought it was going to exceed the MCL. I didn't think there was that threshold, but we had to have some way, because some of the things we were getting were just almost laughable at how small the areas were. So it we couldn't approve those at all.
And a number of areas being excluded. There was farmers there, but no data. I saw that.
We need to balance. We need to balance that effort so we're not overreaching, but at the same time, we're making sure this board is doing their due diligence to properly identify those areas.
Thank you. With that said, we will adjourn. And now that we're